Tonight, we examine a case that has been called Britain's oldest unsolved murder, a killing that prompted one of the longest criminal investigations conducted by a Scottish police force in the 19th century and was never conclusively resolved. A single verdict, delivered after a matter of minutes, left a question standing that has not been answered in more than a century and a half. The case of Janet Rogers begins at Mount Stewart Farm, near the small Perthshire settlement of Forgandenny in the spring of 1866. Forgandenny lay in the fertile agricultural country south of Perth, a district of scattered tenant farms, small hamlets, and long stretches of cultivated land bordered by the Oshill Hills. The parish was not a town in any meaningful sense. It was a rural community organised around the rhythms of the farming calendar, where the movement of people was noticed and remembered, and where a stranger walking the roads between farms would not pass unremarked. Mount Stewart Farm itself was a modest single-occupancy tenant holding, worked by one farmer without the benefit of a resident family of his own, relying on hired labour for the heavier agricultural work and on domestic service for the running of the house. By 1866, Scotland's rural economy remained heavily dependent on this pattern of tenant farming, in which a single farmer held the lease, hired ploughmen and labourers on fixed terms, often for 6 months at a time, and depended on domestic servants to manage the household. Ploughmen in Perthshire were customarily hired at feeing markets, engagements that ran from term to term, and that placed a hired man on the farm grounds for extended periods, often housed close to the farmhouse itself. This was the arrangement at Mount Stewart Farm in the months before the murder. The farm's ploughman had been engaged the previous October, and he worked the land under the direction of the farmer, William Henderson, who held the tenancy and lived at the farm alone. Perthshire in this period was also a county with a significant weaving trade running alongside its agriculture, a domestic and small workshop industry that employed a considerable number of women in the surrounding towns and hamlets. The county's economy was therefore not purely agricultural. It combined the farming calendar with a textile trade that gave women in particular an independent, if modest, source of income. This dual character of the district, farming land worked by hired men, and a weaving economy that ran through many of the same families, forms the immediate backdrop against which the case of Janet Rogers unfolded. The farmhouse at Mount Stewart stood apart from its neighbours in the way that was typical of the district, near enough to other holdings for smoke to be seen and livestock to be heard, but far enough that what happened within its walls on an ordinary afternoon might pass entirely unwitnessed. It was into this setting that Janet Rogers arrived in the last days of March 1866, brought there not by any misfortune of her own, but by an ordinary family obligation, to help her brother in a household that had recently lost its servant and had not yet found a replacement. Janet Rogers was born Janet Henderson, the sister of William Henderson, who held the tenancy of Mount Stewart Farm. William was 2 years younger than his sister, and the two had grown up within the same rural Perthshire community that would later become the setting of the case. The surviving record does not establish the year of Janet's birth with certainty, and no year is given here. What the record does establish is her age at the time of her death, 55 years, a detail confirmed independently in more than one account of the case. She was, by any reasonable calculation, a woman in the later decades of her life when she travelled to her brother's farm in March of 1866. At some point in her early adulthood, Janet married James Rogers, a labourer, and the couple made their home in or near Tully, a small Perthshire hamlet close to Kinclaven and Stanley, some distance from her brother's farm at Forgandenny. By the time of her death, the marriage had lasted approximately 30 years, placing its beginning in the mid-1830s. The surviving record gives no detail of the courtship, the wedding, or the early years of the marriage. It offers instead the outline that survives in most working households of this period: a labourer's wife, managing a household on modest means, in a rural parish where such households were the norm rather than the exception. James and Janet Rogers raised 5 daughters. The eldest, also named Janet, was 28 years old at the time of her mother's death and had herself married to a man named William Paton, with whom she had 3 sons. 2 younger daughters, Anne and Mary Rogers, remained unmarried and continued to live in the family household, both employed as weavers, a trade that placed them squarely within the textile economy that ran alongside Perthshire's agricultural work. The record does not name the 2 remaining daughters individually, nor does it provide detail of their circumstances at the time of the murder. What is established is a family of 5 daughters, a labourer husband, and a household built on the combined income of agricultural wage labour and weaving work, a pattern entirely typical of a Perthshire working family in the middle years of the 19th century. Nothing in the surviving record describes Janet Rogers' personality, her reputation among her neighbours, or the particular character of her domestic life beyond these bare facts of marriage, children, and occupation. No letters, diaries, or personal testimony describing her survive in the sources examined for this account. What can be stated is the outline of a life spent within a single rural district, married for 3 decades to a labouring husband, raising 5 daughters, 2 of whom had entered the same weaving trade that sustained much of the surrounding community. It was this life, ordinary in every respect that the record allows to be documented, that brought her to her brother's farm in the final days of March 1866. If value is found in cases preserved through court records, testimony, and the documents that survive from investigations such as this one, consider liking the video and subscribing to the channel. Let the comments carry word of where the account is being heard. Now back to the record. William Henderson farmed Mount Stewart Farm alone, without a wife of his own, and by the spring of 1866 the household had recently lost its domestic servant. The record does not establish in detail the circumstances under which the previous servant left the position, though a young woman named Christina Miller, who had at some point worked at the farm and was later dismissed from her position there, may have been connected to this vacancy, though the sources available do not confirm this connection with certainty. What is established is that William Henderson required assistance with the running of his household while he sought a replacement, and that he turned to his sister for that help. Janet Rogers travelled from her home at Airntully to Mount Stewart Farm at some point around the 27th of March, approximately 3 days before her death, to take on the domestic duties of the farmhouse in the interim. During those 3 days, Janet Rogers occupied the farmhouse alongside her brother and the farm's hired ploughman, a man named James Crichton, who had been engaged at Mount Stewart Farm the previous October. Crichton worked the land separately from the domestic affairs of the house, in the manner customary for a hired ploughman of this period, and his duties would have kept him largely in the fields and outbuildings rather than within the farmhouse itself. The household during these 3 days therefore consisted of 3 people under one roof or working the same grounds: a farmer, his sister acting temporarily as housekeeper, and a hired labourer engaged some 5 months earlier. The last documented sightings of Janet Rogers on the day of her death come from a hawker named Betsy Riley, who reported having seen her at approximately 11:30 that morning in conversation with an unidentified man near the farm. This identification later proved unreliable. Riley subsequently withdrew the specific detail of the man's identity, citing difficulty with her eyesight, and her credibility as a witness was further undermined when she separately and mistakenly identified a hatter from Aberdeen, a man named John Henderson with no established connection to William Henderson or the case, apparently in pursuit of a reward that had been offered for information. Riley's evidence, once central to the earliest theories of the case, came to be treated with considerable caution by investigators as the case developed. Physical evidence recovered from the farmhouse after the events of that afternoon indicated that Janet Rogers had, at some point that morning, either left the farm briefly or received a visitor. Paper bags found at the scene, one of them containing snuff, suggested a small purchase had been made, a detail of no apparent significance in itself, but one that investigators would later note as part of the reconstruction of her final hours. Beyond this, the record establishes no further confirmed sighting of Janet Rogers between the late morning and the time medical evidence would later fix as the hour of her death, a period placed between 2 and 3 o'clock that same afternoon. It was during this narrow window, with her brother away at the Perth market and the farmhouse otherwise quiet, that Janet Rogers met her death in the kitchen of Mount Stewart Farm. No witness came forward who had seen the act itself. What survives is the physical evidence of the aftermath and the long investigation that followed it. Constable Alexander Cumming was among the first officers to attend Mount Stewart Farm on the evening of the 30th of March, called out following William Henderson's discovery of his sister's body. Within a short time, the case had drawn in a wider body of Perthshire constabulary, including Constable Rowley and Constable John Cameron, working under the direction of Chief Constable Gordon. Superintendent Henry MacDonald took a leading role in coordinating the inquiry as it developed, and Detective Officer James Leadbetter was assigned to the case in the weeks that followed, tasked with the detailed work of tracing movements, gathering statements, and testing the accounts given by those who had been on or near the farm that day. The investigation was formally opened on the strength of the scene itself, the locked doors, the disturbed kitchen, and the absence of any obvious intruder, and it proceeded from the outset on the understanding that whoever had killed Janet Rogers had likely been known to the household or familiar with its routines. Officers examined the farmhouse in detail in the days following the discovery. The bloodied footprints before the fireplace were measured and recorded, and the pair of women's bloodied leather boots found near the bed in the kitchen were retained as evidence, though their precise significance to the reconstruction of events was never conclusively established. The axe believed to have been used in the killing was recovered and examined for traces of blood and hair upon its blade. The broken clay pipe, its tin top separated and pieces missing, was lifted from beneath the body and set aside as an object of particular interest, since it appeared to belong to no one within the household in the ordinary course of things. The 3 paper bags, 2 empty and 1 holding a small quantity of snuff, were also retained, forming part of the physical record assembled in the farmhouse kitchen in the hours and days after Janet Rogers was found. Statements were taken from those in the immediate vicinity of the farm. James Barlas, a neighbour who had been present at or shortly after the discovery of the body, gave an account of the evening's events, as did his wife, John Barlas, who would later provide a detail of some significance that she had observed wash trousers drying outside the cottage occupied by James Crichton on the very day of the murder. Their son, Robert Barlas, was also questioned as part of the wider effort to establish who had been, where, and at what hour across the farm and its immediate surroundings on the 30th of March. An elderly farmer named William Gormack came forward to state that he had observed Crichton returning to his ploughing unusually late that afternoon, at around 3 o'clock, a detail that investigators set carefully against the medical estimate of the time of death. Christina Miller, the young woman who had at some earlier point been employed at Mount Stewart Farm and was no longer in that position by the spring of 1866, was questioned at length and gave testimony that would prove central to the case as it developed. She stated that she had overheard James Crichton tell his wife, Martha Crichton, that if anyone discovered he had killed Janet, he would be hanged. This was not an admission witnessed directly by investigating officers, and its weight rested entirely on Miller's account of a private conversation, a fact that would later be exploited at trial. investigators nonetheless treated it as a significant thread in the case being assembled against Crichton, and it was pursued alongside the physical evidence recovered from the farmhouse. Crichton himself was questioned repeatedly in the weeks following the murder, and his account of his own movements and appearance on the day in question did not remain consistent. Witnesses recalled seeing him in dirty working clothes at around 11:30 that morning, yet by 4 or 5 o'clock that afternoon he was observed in clean white clothing, a change investigators found difficult to reconcile with an ordinary day's ploughing. He denied when questioned that he smoked at all, a denial contradicted by more than one witness who stated that Crichton was known to smoke a pipe regularly, and contradicted further by the broken clay pipe with its tin top found beneath Janet Rogers' body. Investigators noted too that William Henderson had separately accused Crichton of an earlier theft from the farm in January of 1866, when money, a watch and chain, and a pair of trousers had gone missing, an accusation that had never been resolved and that placed a prior tension between the two men well before the events of March. The inquiry into Janet Rogers' death continued for many months beyond the initial weeks of statement-taking and physical examination. Deputy Procurator Fiscal John Young oversaw the gathering of precognitions, the formal statements taken under Scott's procedure to determine whether sufficient evidence existed to bring a case before the Crown. An interim fiscal, James Barty, was engaged in the same process as it extended through the summer and autumn of 1866. Sheriff Barclay was involved in the judicial oversight of these proceedings as the case moved toward a possible indictment. The investigation, taken as a whole, ran from the discovery of the body at the end of March through to the arrest of a suspect in December, a span of some 8.5 months that was described in accounts of the case as the longest-running open murder investigation conducted by a Scottish police force to that date. Officers travelled between Perthshire and Fife in pursuit of witnesses and corroborating detail, and the precognition process gathered statements from every person who had been on or near Mount Stewart Farm in the days surrounding the murder, weighing each account for consistency against the physical evidence recovered from the kitchen. It was on the 15th of December, 1866, that James Crichton was arrested, taken into custody near Dunfermline in Fife, having left the immediate vicinity of Forgandenny in the months since the murder. His arrest came after the accumulated weight of the precognition process, the inconsistencies in his account of his clothing, the pipe found beneath the body, the report of washed trousers drying outside his cottage, and the testimony of Christina Miller regarding the remark overheard between Crichton and his wife. No single piece of this evidence stood alone as conclusive. Taken together, it formed a circumstantial case that investigators believed sufficient to bring before the High Court of Justiciary. William Henderson, for his part, had suspected Crichton from the earliest days of the investigation, a suspicion rooted in the unresolved theft accusation from January and hardened, in the months that followed his sister's death, into a conviction that would not leave him for the remainder of his life. The physical evidence gathered in the course of the investigation was examined alongside the medical findings established in the days immediately following the murder. Dr. Laying, the physician called to examine Janet Rogers' body, was joined in this work by a second physician, Dr. George Absalon, and together their findings formed the basis of the medical record entered into the case. The examination established that death had resulted from severe blows to the head, injuries described as rapidly fatal, and the physicians were able to fix the time of death with reasonable confidence to a window between 2 and 3 o'clock on the afternoon of the 30th of March, a finding that would later be set directly against the witness accounts of James Crichton's movements in the fields that same afternoon. Scott's procedure of the period made no provision for a coroner's inquest in the manner familiar south of the border. Instead, The medical findings were folded into the wider precognition process, overseen by the Procurator Fiscal, forming part of the body of evidence considered in the decision to proceed to trial rather than being aired in a separate inquest hearing before a coroner. The trial of James Crichton opened at the High Court of Justiciary, sitting on circuit in Perth in April of 1867, more than a year after Janet Rogers had been found dead in her brother's kitchen. The court convened before one of the High Court's circuit judges, and the indictment charged Crichton with the murder of Janet Rogers at Mount Stewart Farm on the 30th of March, 1866. The proceedings drew considerable attention from within the county, filling the public benches of the courtroom with residents of Forgandenny and the surrounding parishes who had followed the case since the previous spring, and the trial itself unfolded over more than a single day, extending into a second day of evidence and argument before the matter was placed before the jury. The Crown's case rested on the assembled circumstantial evidence gathered over the preceding year. Witnesses were called in turn to describe Crichton's change of clothing on the afternoon of the murder, from the dirty working garments seen on him at 11:30 that morning to the clean, white clothing observed by 4 or 5 o'clock. William Gormack repeated his account of Crichton returning late to his ploughing at around 3 o'clock, a detail the prosecution set directly against the medical evidence fixing the time of death between 2 and 3. John Barlas gave her account of the washed trousers seen drying outside Crichton's cottage on the day in question, and the broken clay pipe recovered from beneath Janet Rogers' body was produced before the court, set alongside testimony that Crichton habitually smoked a pipe despite his own denial of the habit when first questioned by police. Christina Miller was called to give evidence of the remark she said she had overheard between Crichton and his wife, that if anyone discovered he had killed Janet he would be hanged. Her appearance in the witness box proved to be one of the most contested moments of the trial. Defence counsel Charles Scott rose to cross-examine her at length, directing his questions not at the substance of what she claimed to have heard but at her own personal history and her relationships with several men. A line of questioning intended to weaken the jury's confidence in her reliability as a witness rather than to contest the words she attributed to Crichton directly. This approach was consistent with the defence tactics permitted under the procedure of the day, and it appeared to have a marked effect on how her testimony was subsequently weighed by those present in the courtroom. The defence built its case on the entirely circumstantial nature of the evidence brought against Crichton, arguing that no witness had seen him commit any act of violence, that the physical evidence connecting him to the kitchen where Janet Rogers died was suggestive rather than conclusive, and that inconsistencies in a man's account of his own clothing or habits, however troubling, fell short of proof beyond reasonable doubt. Scott pressed the jury to consider that suspicion, however widely shared within the district, was not the same as certainty, and that the Crown had produced no single piece of evidence that placed Crichton's hand upon the weapon or within the kitchen at the hour in question. He returned repeatedly to the absence of any direct witness to the killing itself, a fact the Crown did not dispute. Betsy Riley's earlier evidence, once treated as a promising thread in the investigation, played little part in the trial itself, her credibility having been substantially undermined by her withdrawn identification and her separate, mistaken accusation against the Aberdeen hatter. The prosecution did not lean upon her testimony in building its case before the jury, relying instead on the accumulated weight of the clothing discrepancies, the pipe, the trousers, Gormack's account of the ploughing, and Miller's disputed testimony of the overheard remark. The presiding judge summed up the evidence for the jury at length, setting out the standard the Crown was required to meet, and reminding those assembled that a verdict of guilty required proof beyond reasonable doubt, not merely a conclusion that Crichton was the most likely person to have committed the act. The jury retired to consider its verdict following the judge's charge, and the courtroom remained in a state of close attention through the period of their deliberation. The jury did not remain out for long. Within what accounts of the case describe as barely 11 minutes, the jury returned to deliver its verdict, a period so brief that it drew comment from those who had expected a longer and more searching deliberation given the volume of evidence presented over the preceding days. The verdict returned was not proven, a finding available under Scots law that sits between an outright acquittal and a conviction, indicating that the jury found insufficient certainty to convict while stopping short of declaring Crichton innocent of the charge. James Crichton was discharged from the dock and released from custody immediately following the verdict, a free man in the eyes of the law, though not a man cleared of suspicion in the eyes of many who had followed the case. No sentence followed the verdict of not proven, since Scots law treats that finding as neither a conviction requiring punishment nor a full acquittal requiring further explanation, and James Crichton left the court at Perth without any term of imprisonment or further legal obligation placed upon him. He did not, however, return to a district willing to set the matter aside. In the weeks and months that followed his release, Crichton found himself the object of sustained local suspicion, a burden that followed him through the ordinary business of daily life in a rural community where the case had been discussed in every household for more than a year. Neighbours who had once exchanged the customary courtesies of farm life were reported to have grown cold toward him, and the presence of a man tried for murder and released without a clear finding of innocence proved difficult for the community of Forgandenny to absorb into its ordinary rhythms. Within a relatively short period, Crichton left the district altogether, relocating to Fife, a distance of some 19 miles from Mount Stewart Farm, where he took up work again as a labourer among people less immediately acquainted with the particulars of the case that had followed him from Perthshire. William Henderson did not receive the verdict as a resolution. He had suspected Crichton from the earliest days of the investigation, a suspicion that had its roots in the unresolved accusation of theft from the previous January, and the acquittal, if it could be called that, did nothing to dislodge the conviction he carried privately that his sister's killer had walked free from the court at Perth. In the years that followed the trial, Henderson's mental health began a decline that those close to him and later chroniclers of the case linked directly to his inability to set the matter to rest. He left Mount Stewart Farm at some point in the years after the trial and moved to New Scone, a village closer to Perth, continuing to farm or labour in some capacity while the unresolved question of his sister's death remained, by every account, a constant undercurrent in his private life. The record indicates that William Henderson was committed to the Murray Royal Asylum at Scone at some point in 1881, some 15 years after the murder of his sister, and that this was not a single admission, but one of several over the years that followed, a pattern suggesting a chronic and worsening condition rather than an isolated episode of distress. Attendants and physicians at the asylum, according to the fuller accounts of the case, recorded that Henderson continued to speak of the murder and of Crichton's trial even in his periods of most severe illness, returning again and again in his private ramblings to the events of March 1866 and to the verdict that had never satisfied him. He died within the walls of the asylum on the 22nd of January 1890 at the age of 77, and the accounts describing his final years note that he died in a state of acute mania, still speaking of the murder and of what he continued to call, in his own words, his own apprehension and acquittal, a curious phrase suggesting that in his final confusion he had come in some fashion to conflate his sister's death with a sense of guilt or suspicion cast upon himself. James Crichton's later years are recorded with far less certainty than those of William Henderson. What is established is that he continued to labour in Fife for the remainder of his working life, at a distance from the Perthshire community in which he had once been hired as a ploughman and later stood trial for murder. He died in 1894 at Milton in the parish of Markinch, Fife. The cause of death recorded as gangrene. What can be said is that he lived out his years under the shadow of a case that had never produced a conviction against him, yet had never fully cleared his name in the eyes of the district in which the killing had taken place, a position that afforded him neither the vindication of an acquittal widely accepted as final, nor the closure that a conviction, however grim, might have brought to those who continued to believe in his guilt. The absence of any further prosecution meant that no one else was ever charged in connection with the death of Janet Rogers. The case having produced a trial, a jury, and a verdict that settled nothing in the eyes of the law beyond the immediate discharge of the one man brought before the court, remained formally open in the historical sense, even as the file itself passed out of active investigation. In the years following the trial, a theory took shape among those who examined the case more closely, a theory not advanced at the time of the trial itself, but developed later through closer study of the surviving precognitions and witness statements, that William Henderson's own conduct in the early stages of the investigation may have shaped the course the inquiry took against Crichton more than the physical evidence alone could justify. This theory rests on the observation that Henderson had accused Crichton of theft some 2 months before the murder, a grievance that placed suspicion in Henderson's mind well before any evidence connected Crichton to his sister's death, and that Henderson, standing within the community as the victim's own brother, lent his suspicions a weight in the early investigation that a more neutral party's accusations might not have carried. The historian who examined the case in greatest depth in the modern era presents this reading as a plausible interpretation of the surviving record rather than as an established fact, noting that no direct evidence of deliberate fabrication on Henderson's part survives, only the pattern of a grieving brother whose pre-existing animus toward a hired servant coincided, perhaps only coincidentally, with the direction the case against Crichton eventually took. The case of Janet Rogers did not pass entirely from public notice in the years that followed the trial at Perth, though its survival owed more to the persistence of local memory and periodic scholarly attention than to any wide national fame of the kind attached to certain other criminal cases of the Victorian period. Within Perthshire itself, the killing at Mount Stewart Farm remained a case that continued to surface in conversation and in print across successive generations, carried forward by the region's own newspapers, which returned to the story at intervals over the decades that followed, treating it as a piece of local history that had never been properly closed. The Courier, the long-running Dundee and Perth regional newspaper, published retrospective features on the case in later years, reintroducing the details of the murder, the investigation, and the trial to readers for whom the events of 1866 had passed beyond living memory, and in doing so kept the case within the active historical consciousness of the district rather than allowing it to fade entirely into the general record of unsolved Victorian crime. The most substantial modern treatment of the case came in 2012 with the publication of a book by the genealogist and historian Chris Paton titled The Mount Stewart Murder, a re-examination of the UK's oldest unsolved murder case, issued by the History Press. Paton's work drew together the surviving precognitions, trial reports, and press coverage of the case into a single sustained account. And it was this book that most firmly established the case's claim to the description that has followed it since, that of the oldest unsolved murder case in the United Kingdom. The book's re-examination of the evidence against James Crichton and its consideration of the possibility that William Henderson's own conduct may have shaped the direction of the original investigation gave the case a renewed circulation among readers with an interest in Scottish criminal history and in the particular procedural puzzle of the not-proven verdict. The case found a further audience in more recent years through audio treatment, appearing as a dedicated episode of the podcast Scottish Murders, a programme that gathered and presented many of the same names and details that had first been assembled in the precognition process of 1866, carrying the case to listeners with no direct connection to Perthshire, and extending its reach beyond the readership of the regional press and Paton's book. Between the newspaper retrospectives, the book, and the podcast treatment, the case of Janet Rogers has continued to be examined and discussed well over a century after the verdict was delivered at Perth, sustained less by any single dramatic adaptation than by the durable interest that attaches to an unresolved question, particularly one carrying the distinction of being the oldest such case on formal record in the United Kingdom. The Mount Stewart murder holds its place in Scottish criminal history, in large part because of the unusual duration of its investigation. An inquiry that ran for the better part of 9 months between the discovery of the body at the end of March 1866 and the arrest of James Crichton in December of that year, a span of time that accounts of Scottish policing in this period single out as among the longest sustained murder investigations conducted by any force in the country up to that date. This duration reflects both the difficulty of the case, resting as it did entirely on circumstantial evidence gathered slowly through the precognition process, and the seriousness with which the Perthshire Constabulary and the Office of the Procurator Fiscal pursued a killing that had occurred within a small and closely observed rural community. The case also stands as a clear illustration of the particular character of the not proven verdict within Scots law, a finding unique to Scotland's criminal procedure that allowed a jury to express genuine and considerable suspicion without being compelled to either the certainty required for conviction or the clean exoneration implied by a verdict of not guilty. Within Perthshire, the murder of Janet Rogers is remembered as a case that unsettled a rural community accustomed to the ordinary and largely predictable rhythms of farm life, a community in which a hired ploughman, a visiting sister, and an absent farmer at market represented as unremarkable an arrangement as could be found across the county that spring. The killing disrupted that ordinariness in a manner from which the district did not fully recover, at least not in the sense of ever settling with confidence upon an answer to the central question the case had raised. Mount Stewart Farm itself continued to exist within the agricultural life of Forgandenny parish in the years that followed, its fields worked and its buildings maintained in the ordinary course of a farming tenancy, even as the events of one particular afternoon in March 1866 remained attached to its name in the historical record long after the individuals directly involved had themselves passed from living memory. The investigation into Janet Rogers' death was formally closed without a conviction ever being secured against any party. The case remains open in the historical record, and no arrest beyond that of James Crichton, whose trial ended in a verdict of not proven, was ever made in connection with her death. William Henderson's return to Mount Stewart Farm on the evening of the 30th of March followed the ordinary pattern of a market day. The business of Perth concluded in the early evening hours, and the journey home, undertaken in the fading light of a late Perthshire spring, a journey he would have made many times before without incident. He arrived at the farm at approximately 7 o'clock that evening, drawing near the house in the half-light that settles over the Perthshire countryside at that hour in late March, and finding the farmhouse unusually quiet, without the ordinary signs of a household preparing for the evening. The front door of the house was locked, a circumstance that struck him as out of the ordinary, given that his sister had been left within the house for the day and would have expected his return. He tried the door a second time, and finding it would not give, made his way around the building to test the other points of entry, discovering in the course of this search that a bedroom window at the side of the house had been left unlocked, or had come open in some fashion that allowed him passage into the building. He entered the farmhouse through this window, an entry that required him to climb into the building rather than pass through it by an ordinary door, and made his way through the darkened rooms, calling for his sister as he went. The kitchen the room at the functional heart of the farmhouse, was where he found her. Janet Rogers lay on the floor of the kitchen, her body marked by the injuries that had caused her death some hours before. The blood that had spread across the furniture and walls of the room by then dried in the cooling air of the evening. William Henderson's discovery of his sister's body in these circumstances, alone in the house he had left that morning in the ordinary expectation of an uneventful day at market, marked the moment at which an otherwise unremarkable spring day in the parish of Forgandenny became the opening scene of a criminal investigation that would occupy the Perthshire constabulary for the better part of a year. A neighbour, James Barlas, is recorded as having been present at or shortly following this discovery, drawn to the farmhouse either by Henderson's own alarm or by some other circumstance that brought him to Mount Stewart Farm in the immediate aftermath of the finding of the body. It would have fallen to Barlas, in the manner customary to a rural community of this kind, to assist Henderson in the first urgent tasks that followed such a discovery, the raising of the alarm among neighbouring households and the sending of word toward the nearest constable, tasks that in a district of scattered farms, without immediate access to a telegraph or a police station, could not be accomplished within minutes, and that would have required a journey on foot or on horseback through the dark countryside to bring the first officers of the law to the scene. The interval between the discovery of the body at 7 o'clock and the arrival of Constable Alexander Cumming and his colleagues would therefore have stretched across a portion of that evening, a period in which the farmhouse remained in the charge of Henderson, and whatever neighbours had gathered in response to the alarm, the body of Janet Rogers left, as it had been found, until the officers of the law could examine the scene for themselves. James Rogers, Janet's husband, did not learn of his wife's death until several days after the event itself, a delay explained by the distance between his home at Tully and his brother-in-law's farm at Forgandenny, a distance that, in the absence of rapid means of communication common to a later era, meant that word of the killing travelled by the same slow channels as any other piece of rural news, carried from household to household and parish to parish, by whoever happened to be making the journey between the two districts. It was on the Saturday following the murder, some days after the event, that James Rogers arrived at Mount Stewart Farm and was confronted directly with the death of his wife of some 30 years, learning in person, at the scene itself, of the manner and circumstances in which she had died. The record does not elaborate upon the substance of that arrival, beyond establishing that it occurred, that Rogers made the journey from Tully to the farm, and that he discovered the fact of his wife's death upon reaching Mount Stewart, rather than through any earlier notice sent to him at his own home. For a labouring man of modest means in rural Perthshire, such a journey, undertaken without foreknowledge of what awaited him, would have been made along roads and byways that offered no comfort in the travelling, and the household he returned to at Tully in the days that followed would have been one from which its mistress of 3 decades had been permanently and violently removed. The 5 daughters of James and Janet Rogers were similarly drawn into the aftermath of a death none of them had witnessed and none had been prepared for. Anne and Mary Rogers, the 2 unmarried daughters still resident in the family household and employed in the weaving trade that ran alongside so much of the domestic economy of the district, would have continued their working lives in the immediate wake of their mother's death, since a weaver's income, however modest, could not simply be set aside in a household that had lost the additional contribution their mother's presence had made to its running. The eldest daughter, Janet, married to William Paton and raising 3 sons of her own by 1866, faced the loss of her mother while managing a household of her own, a burden common enough to daughters of this period who were expected to absorb such losses within the ordinary continuation of their domestic duties, without any interruption to the care of husband, children, or home that the period demanded of a married woman. The weaving trade in which Anne and Mary Rogers were employed formed a substantial part of the Perthshire economy in the middle years of the 19th century, operating alongside the county's agricultural base rather than in competition with it, and offering women of labouring families a source of independent wage income that supplemented what a husband or father might bring home from farm labour. Weaving of this kind was frequently conducted within small workshops or in arrangements close to a family's own home, allowing daughters to contribute to the household economy while remaining under its roof, a pattern that placed Anne and Mary Rogers squarely within a recognisable category of working women common to Perthshire's towns and larger villages. The trade demanded long hours at the loom and a steady, repetitive labour that produced cloth for a market extending well beyond the immediate district, and it stood in the domestic economy of a family such as the Rogers household as a second and necessary pillar alongside James Rogers's own wages as a labourer. The system by which James Crichton had come to be hired at Mount Stewart Farm the previous October reflected a labour arrangement common across rural Perthshire and much of lowland Scotland in this period. The practice of feeing, by which farmers and labourers came together at designated markets, typically held twice yearly at the terms of Whitsunday and Martinmas, to agree terms of engagement for a fixed period of service. A ploughman engaged under such an arrangement would commit himself to a single farm for the length of the term, receiving in exchange a wage and very often lodging on or near the farm itself, an arrangement that placed him in close and sustained proximity to the household he served, even though his labour was confined chiefly to the fields rather than the house. Crichton's engagement at Mount Stewart Farm from October 1865 placed him, by the following spring, 5 months into a term of service that would ordinarily have continued through to the following feeing market, a term interrupted in the most serious way imaginable by the events of the 30th of March and by his arrest that December, well before any natural conclusion to his period of hire could have been reached. Perth itself, the county town toward which William Henderson had travelled on the morning of the murder, stood as the principal market centre for the surrounding agricultural district, a town of some considerable size by the standards of rural Perthshire, drawing farmers, labourers and tradesmen from across the county on market days to conduct the business of buying and selling livestock, produce and goods that sustained the rural economy. A market day in Perth would have brought Henderson into contact with a great many people beyond his own immediate household. Farmers and dealers engaged in the same seasonal business that drew men from every parish within a reasonable travelling distance of the town, and it was this same ordinary and unremarkable business that had taken him away from his farm on the one day that would come to define the case attached to his family's name for more than a century afterward. The court that would later try James Crichton sat within this same town, the High Court of Justiciary, convening on its Perth circuit in buildings that served the judicial needs of the county in the same manner that the market square served its commercial needs. And it was to this town that witnesses, officers, and the accused himself were all drawn in April of 1867, just as Henderson himself had been drawn there on an ordinary Friday morning some 13 months before. Word of the verdict spread through Perth within the hour, carried out from the courtroom into the streets surrounding the court buildings by those who had crowded the public benches through the 2 days of testimony and argument. A verdict of not proven was, by the standards of the county's own legal tradition, no stranger to Scottish courts, yet the particular circumstances of this case, a killing within a small and closely bound farming community, a suspect who had lived and worked among his accusers for months before his arrest, and a trial that had drawn spectators from parishes well beyond Forgandenny itself, meant that the verdict was received with an unusual intensity of feeling among those gathered outside the court that day. Some among the crowd are reported to have expressed open disappointment at a result that left the question of guilt formally unsettled, while others regarded the verdict as the only honest outcome available to a jury asked to convict on evidence that, however suggestive, fell short of placing the axe directly in Crichton's hand. Crichton himself was seen to leave the court building under guard from the crush of onlookers, rather than through any wish of his own to draw attention. His release from custody, accomplished with rather less ceremony than his arrest some 4 months earlier, had commanded. The not proven verdict itself carried a long history within Scots criminal procedure by the time it was returned in the case of James Crichton, tracing its origins to a period well before the 19th century, when Scottish juries were originally required to return findings only on specific facts put to them, rather than a general verdict of guilty or not guilty, a practice that evolved over time into the 3-verdict system that Scots law retained into the Victorian era and beyond: guilty, not guilty, and not proven, the last of these understood in practice as a jury's acknowledgement of substantial suspicion falling short of the certainty the law demanded for conviction. The verdict has often been characterised, both in the legal commentary of the period and in later description, as leaving a defendant in a state of suspended judgment, formally free of conviction, yet without the clean discharge that a verdict of not guilty was understood to carry in the eyes of the community. This distinction mattered a great deal in a case such as this one, tried within a rural county where the accused would be required to continue living, however briefly, among the very neighbours who had furnished evidence against him and who now had to reconcile a legal outcome that resolved nothing to their own satisfaction. In Fife, in the years that followed his relocation from Perthshire, James Crichton took up the life of an agricultural labourer in a district where his name did not carry the same immediate association it had come to carry around Forgandenny, though the distance of 19 miles was not so great as to place him entirely beyond the reach of those who might recognise him or have heard the particulars of the Mount Stewart case through the same channels of rural gossip and newspaper coverage that had carried news of the trial across the county in the spring of 1867. He continued to work as a hired labourer, engaging in the same kind of agricultural service that had brought him to Mount Stewart Farm in the first place. His days given over, once again, to the fields, the livestock, and the seasonal demands of a farming calendar that made no allowance for the particular history a labourer carried with him from one district to the next. Martha Crichton, his wife, whose private conversation with her husband had formed so significant a part of the testimony given against him by Christina Miller, is not recorded as having left any further account of her own regarding the case. Her presence in the surviving record confined to the single, overheard remark that had so nearly determined her husband's fate before a Perth jury. The physicians who had examined Janet Rogers's body in the days immediately following her death, Dr. Lying and Dr. George Absolon, appear in the surviving record only in connection with their professional findings. Their names entered into the case file as the medical authorities whose examination established the cause and approximate time of death, without further biographical detail surviving as to their standing or practice within the county. Their conclusions, reached in the direct aftermath of the discovery of the body, before the wider investigation had gathered pace and before any suspect had been named, carried a particular weight in the case, precisely because they were arrived at independently of the circumstantial evidence that would later be assembled against Crichton, the medical timeline of death between 2 and 3 o'clock in the afternoon, standing as a fixed point against which every subsequent witness account of movement and appearance on the farm that day would be measured. The Murray Royal Asylum, to which William Henderson was committed in 1881, and to which he returned on more than one occasion in the years that followed, stood among the principal institutions in Scotland for the care of those suffering from mental illness. In this period, a large establishment at Scone maintained under the medical and administrative practices typical of Victorian asylum care, in which patients suffering from conditions understood by the physicians of the day as forms of mania or melancholia were housed, observed, and treated according to the therapeutic understanding of the time. Admission to such an institution was not undertaken lightly by a family or by the medical authorities responsible for certifying a patient's condition, and Henderson's repeated admissions across the final decade of his life point to a chronic and recurring illness rather than any single crisis, an illness that the fuller accounts of the case link directly and specifically to his sister's murder and the verdict that had followed it, though no formal medical diagnosis beyond the general description of mania survives in connection with his case. The identity of the perpetrator was not established, no conviction followed, none was ever sought. The case of Sarah Squires begins in Hoxton, in the borough of Shoreditch, in the county of Middlesex, in the year 1872. Hoxton, at this time, formed a densely populated district in the northeastern portion of London, bordered by Shoreditch to the south and Islington to the west, home to a working population engaged principally in small trade, manufacturing and shopkeeping. The area had grown rapidly over the preceding decades as London's population expanded outward from the historic city centre, and by the early 1870s, Hoxton was characterised by rows of terraced houses, many combining ground-floor commercial premises with living quarters above or behind the shop itself. Hyde Road ran through the heart of this district, a thoroughfare of modest shops serving the immediate neighbourhood, its pavements busy through the working day with tradespeople, customers, and the ordinary traffic of a London summer. The year 1872 fell within a period of steady, if unspectacular, growth for the district. Hoxton had not yet acquired the particular reputation for poverty and criminality that would attach to it in later decades, though it remained a district of limited means, populated largely by artisans, small tradespeople, and their families. The streets were lined with terraced houses 2 and 3 stories in height, many with shop fronts let out to grocers, chandlers, print sellers, and other small merchants who lived above or behind their places of business. Gas lighting had reached most of the principal streets by this date, and the London County Council's later reforms of sanitation and housing still lay some years in the future. The summer of 1872 was, by contemporary account, an unremarkable one for the district, without epidemic, civil disturbance, or other event of note preceding the crime that would bring Hyde Road to national attention. Number 46. Hyde Road stood among these premises as a leasehold property owned and occupied by Sarah Squires, a widow who conducted a wholesale trade in pictures and prints from the ground floor of the building, with living quarters attached to the rear and above. The trade in prints and engravings was a common one in Victorian London, serving both retail customers and other tradespeople who purchased stock for resale, and it provided Sarah Squires with an independent livelihood at a stage of life when many widows of similar circumstances depended upon relatives or parish relief. She was assisted in the running of the business and household by her daughter Christiana, who remained unmarried and lived with her mother at the Hyde Road address. The precise ages of both women are subject to some variation across the surviving record. Sarah Squires is recorded in different accounts as 73, 76, or 77 years of age, and Christiana as approximately 30, 36, or 48. The most consistent pairing across independent sources places Sarah in her late 70s and Christiana in her 30s, and this account follows that pairing while acknowledging that precise certainty on the point is not available in the surviving record. Sarah Squires had several adult children beyond Christiana. A grandson, George Squires, 17 years of age and apprenticed to the trade of hairdressing, had visited the Hyde Road premises approximately 3 weeks before the events of July 1872. A son named Frank had previously been a patient at Colney Hatch Lunatic Asylum, an institution serving Middlesex for the care of the mentally ill, and by the summer of 1872 he resided in the infirmary of the Shoreditch workhouse. Another son, Edward, worked as a musician and was frequently absent from London on professional engagements. An eldest daughter, Jemima, had established her own household in Bow, some distance from Hyde Road, and did not reside with her mother and sister. The family's circumstances, while not affluent, reflected a household of established, respectable trade, with Sarah Squires maintaining her independence as a property-holding tradeswoman well into old age. Of Sarah and Christiana Squires, beyond these facts of trade, family and residence, the surviving record offers little. Neither woman left behind letters, diaries, or other personal documents that have come down through the historical record reviewed for this account. What can be established is confined to their trade, their household, and the small number of documented interactions with neighbours and family in the days preceding the events of the 10th of July. This absence of personal detail is not unusual for women of their station in this period, whose lives were recorded chiefly through the formal instruments of trade, taxation, and, in this case, criminal investigation, rather than through private correspondence intended for posterity. What the record does establish is a household of two women, mother and daughter, conducting an ordinary trade from an ordinary shop on an ordinary London street, their days structured by the rhythms of commerce rather than by any circumstance that might have marked them for particular attention before the summer of 1872. Christiana Squires had, at an earlier point, been courted by a stonemason named George Niblet. The relationship between them had since ended, though the precise circumstances of its conclusion are not established in the sources reviewed. Niblet would later be investigated in connection with the events at Hyde Road, a matter addressed in fuller detail in the account of the investigation that follows. Beyond this connection, no other personal relationships involving either woman are documented with particularity in the surviving record. The premises at 46 Hyde Road combined, in the manner typical of small Victorian trade, both the commercial and domestic functions of the household within a single building. The shop occupied the ground floor at the front of the property, with a counter for the display and sale of stock, while a back parlour and further rooms extended behind, and presumably above the shop itself, serving as the living quarters for Sarah and Christiana Squires. This arrangement, common among shopkeepers of the period, meant that the boundary between the world of trade and the world of the household was, in a practical sense, only a few steps and a doorway. It is a detail of some significance to the events that would unfold on the 10th of July as the sequence of that day's violence appears, from the physical evidence later documented, to have moved from the shop counter toward the passage connecting it to the parlour behind. In the days preceding the 10th of July, one incident is documented that bears directly upon the circumstances leading to the crime. On the Saturday preceding the murders, corresponding to the 6th of July, an attempt was made to break into the premises at 46 Hyde Road. The surviving record does not establish who made this attempt, what was taken or damaged, or whether the matter was reported to the police at the time. It stands in the record as a documented precursor, an indication that the premises had, in the days before the killings, already drawn the attention of someone with apparent intent to enter unlawfully. Whether this earlier attempt bore any direct relation to the events of the 10th of July was never established by the subsequent investigation, and no source reviewed for this account draws a confirmed connection between the two incidents beyond their proximity in time and place. The morning of Wednesday, the 10th of July, began in the ordinary manner of any trading day at Hyde Road. The shop shutters were taken down, as usual, according to witness testimony given at the subsequent inquest, and this task was performed by Christiana Squires herself. The opening of the shop in this fashion indicates that the household proceeded through its usual morning routine without any indication, so far as the surviving witnesses could later attest, of disturbance or apprehension. Trade appears to have continued through the morning hours in the customary way, with Christiana observed by multiple witnesses at various points between 9 and 11 o'clock, moving about the frontage of the shop in the course of her ordinary duties. At approximately 11 o'clock in the morning, a butcher named Henry Innell, who conducted business in the vicinity of Hyde Road, spoke with Sarah Squires. The content of this conversation is not recorded in detail in the sources reviewed, but its occurrence establishes with reasonable certainty that Sarah Squires was alive and engaged in ordinary conversation at 11 o'clock that morning. This exchange represents one of the last confirmed sightings of Sarah Squires before the discovery of the crime, and it would later serve as an anchor point in the effort to reconstruct the timeline of that day's events. The reconstruction of the following hour and a half, between approximately 11 o'clock and 12:30, produced one of the central and unresolved puzzles of the case. A witness named Charles Wallen, a carman by trade, reported seeing two men behaving in a manner he considered suspicious in the vicinity of the house at approximately 11:30 that morning. Wallen's account did not include any description sufficiently detailed to permit later identification of these men, and no other witness came forward to corroborate the sighting independently. Separately, and in apparent contradiction to other evidence gathered in the course of the investigation, a witness maintained that Sarah Squires had been observed standing in the doorway of her own shop as late as 12:30, a full half hour or more after other evidence suggested the attack upon her had already taken place. This contradiction was never resolved by the investigators who examined the case, and it remains, in the surviving record, an open question rather than a settled point of fact. The physical evidence bearing most directly upon the question of timing was a clock kept in the parlour of the premises, which was found knocked to the ground and stopped, its hands fixed at 12 o'clock, noon. Investigators at the time took this as an indication that the violence in the household had occurred at or around midday, consistent with the disruption of the room in which the clock stood. Yet this piece of evidence stood in direct tension with the witness account placing Sarah Squires alive and visible in her shop doorway a half hour later. The investigation was never able to reconcile these two threads of evidence, and the surviving record preserves the contradiction rather than resolving it. It is presented here as it stands in that record, an unresolved tension between a stopped clock and a witness's recollection, neither definitively established as more reliable than the other. The formal discovery of the crime came at approximately 1:30 in the afternoon. A boy named William Eyre, sent on an errand that, according to one account, involved the purchase of a newspaper, entered the shop at 46 Hyde Road and observed blood and hair upon the counter, with further traces sprinkled across papers and stock displayed nearby. Recognising the significance of what he'd found, Eyre did not proceed further into the premises, but instead sought assistance from a neighbouring tradesman, a greengrocer and coffee shop proprietor named Mr. Dodd, whose premises stood in the immediate vicinity. Dodd, upon hearing Eyre's account, and likely viewing the scene for himself, summoned the police without delay. The response to Dodd's alarm brought Police Constable James Kingsley to the premises, and it was Kingsley who made the formal discovery of the bodies of Sarah and Christiana Squires within the house. The scene that greeted him, according to the record of subsequent proceedings, showed clear evidence of violence and disorder throughout the premises. Drawers and boxes had been forced open and their contents disturbed. Furniture had been displaced in multiple rooms, and the overall condition of the premises was consistent with a thorough search having been conducted, whether by the perpetrator or perpetrators in search of money and valuables, or in some other pursuit not established by the surviving evidence. Sarah Squires was found behind the counter of the shop, in the area where she would ordinarily have conducted business with customers. Christiana Squires was found some distance away, her body positioned partly within the passage connecting the shop to the rear of the premises and partly within the back parlour itself, a positioning that later investigators would interpret as consistent with an attempt to reach or assist her mother in the course of the attack. The reflective summary of this stage of the case rests upon a small number of established facts and a larger number of unresolved questions. The household had proceeded through an ordinary morning of trade. Sarah Squires was confirmed alive at 11 o'clock. A contested sighting placed her alive as late as 12:30, in direct tension with the physical evidence of the stopped clock. No witness came forward who had observed the attack itself, and the identity of the two men reported near the premises at 11:30 was never established. The discovery, when it came, was sudden, and it fell to a boy sent on an ordinary errand to bring the violence at 46 Hyde Road to the attention of the authorities. The examination of the bodies fell to Dr. Hawthorne, a police surgeon called to the scene following Constable Kingsley's discovery. Hawthorne's examination, conducted at the premises, established that both women had died as the result of heavy blows delivered to the head with a blunt instrument. The nature of the injuries was sufficient to indicate to Hawthorne that death in each case had followed rapidly upon the injuries sustained. The instrument responsible for the injuries was never recovered in the course of the investigation, though the nature of the wounds led investigators to theorise that a hammer or a similar iron implement had been employed, with one source specifying the type of tool as a plasterer's hammer. This identification remained a matter of inference, drawn from the character of the wounds rather than a conclusion supported by the recovery of a weapon, and it should be understood accordingly. Hawthorne's examination did not establish a precise time of death for either woman with any exactitude, a limitation consistent with the medical practice of the period, in which the estimation of the interval since death relied upon observations of the body's temperature and condition that permitted only an approximate range rather than a fixed hour. The stopped clock fixed at 12 o'clock remained the most specific piece of evidence bearing on the question of timing, though as already noted, this evidence stood in unresolved tension with the witness testimony placing Sarah Squires alive at 12:30. No further medical inconsistencies or points of dispute are recorded in the sources reviewed for this account. Hawthorne's findings were subsequently presented to the coroner's inquest convened to examine the circumstances of the deaths, and it is to that inquest that attention now turns. The investigation into the deaths of Sarah and Christiana Squires was formally opened in the hours following the discovery of the bodies, under the direction of Inspector Ramsey of N Division, the division of the Metropolitan Police, responsible for the district encompassing Hoxton. Ramsey's initial examination of the premises was followed by the assignment of 2 experienced detectives to pursue the inquiry further, a measure reflecting the seriousness with which the double killing was regarded by the police from the outset. Officers were dispatched to canvass the immediate vicinity of Hyde Road, seeking any person who might have observed unusual activity at or near the premises on the morning of the 10th of July, and statements were taken from neighbours, tradespeople, and family members in the days that followed. The early progress of this canvass produced little in the way of concrete result. Contemporary press accounts from the first days following the discovery noted that the police had, at that stage, no clue as to the identity of the perpetrator or perpetrators, and suspected no particular individual. This absence of an early breakthrough was a source of evident frustration both to the investigating officers and to the public, whose attention had been drawn to the case by the extensive newspaper coverage the killings received under the name subsequently attached to them by the press, the Hoxton Horror. As the investigation continued without producing an arrest, a reward was offered for information leading to the identification and apprehension of those responsible, and this reward was subsequently increased to £200, a substantial sum reflecting both the gravity of the crime and the investigators' hope that financial incentive might succeed where conventional inquiry had not. Among the specific lines of inquiry pursued by the investigating officers was the examination of family members with any connection to the household at Hyde Road. Frank Squires, Sarah's son, who resided at the time in the infirmary of the Shoreditch Workhouse following his earlier treatment at Colney Hatch Lunatic Asylum, was investigated in connection with the killings. This inquiry established that Frank Squires had been present and engaged in his ordinary activities at the workhouse throughout the period during which the murders were believed to have occurred, an alibi that was verified to the satisfaction of the investigating officers, and he was accordingly cleared of any suspicion. It should be noted that one contemporary source, reflecting an earlier and less complete stage of press reporting, described this institutionalised relative as a brother of Christiana Squires, confined in the workhouse's lunatic ward, rather than as Sarah Squires' son. The more detailed account of the family, drawn from the fuller record of the inquest proceedings, identifies him as Frank, her son, and this account follows that identification, while noting the discrepancy for the sake of completeness. Edward Squires, another of Sarah's sons, was likewise investigated. Edward worked as a musician and was, at the time of the killings, engaged in a professional engagement at Brentwood, some distance outside London. This absence from the city was verified in the course of the investigation, and Edward Squires was cleared of suspicion on this basis. The investigation of family members extended as well to George Niblett, the stonemason who had previously courted Christiana Squires before the end of their relationship. Niblett's whereabouts on the morning of the 10th of July were examined, and it was established that he had been at his place of work throughout the relevant period, an alibi likewise verified to the satisfaction of the investigating officers. He too was cleared of any suspicion in connection with the killings, with the family members and known associates of the household investigated and cleared. The inquiry turned to the physical evidence recovered from the premises for further indication of the perpetrator's identity or motive. Among the items discovered during the search of the house was a will made by Sarah Squires, found beneath a sofa in the premises. The circumstances by which this document came to be in that location are not established in the surviving record. It may have been placed there by Sarah Squires herself for safekeeping, or it may have been disturbed from some other location in the course of the ransacking that characterised the scene, or it may bear some other explanation, not preserved in the sources reviewed. The investigators did not, so far as the record establishes, draw any definite conclusion from this discovery, and it is presented here as a documented detail of the scene, rather than as evidence pointing toward any particular theory of the crime. The overall character of the scene, with drawers forced and furniture disturbed throughout multiple rooms of the premises, was consistent with the investigators' working theory that the motive for the crime had been robbery. No account reviewed for this research identifies with confidence what, if anything, was taken from the premises, nor does the surviving record establish the value of any property that may have been removed by the perpetrator or perpetrators. The investigation proceeded on the assumption of a robbery gone to lethal extremity, a theory consistent with the physical disorder of the scene, though it remained, as with so much of this case, a theory rather than a conclusion, supported by direct evidence of the perpetrator's identity or intent. As the weeks following the discovery passed without an arrest, the investigation gradually exhausted the leads available to it. The canvass of witnesses in the vicinity of Hyde Road, the examination of family members and known associates, and the offer of a substantial reward together failed to produce information sufficient to identify those responsible for the deaths of Sarah and Christiana Squires. The case, notorious in its own time under the name the Hoxton Horror, entered a period in which official activity diminished even as public and press interest in the unresolved killings persisted. The reflective summary of the investigation, then, is one of thorough and conscientious effort by the officers assigned to the case, producing the elimination of every specific suspect brought to their attention, but never producing the identification of the individual or individuals actually responsible. The inquest into the deaths of Sarah and Christiana Squires was convened at the Shoreditch Workhouse under the direction of Mr. Humphreys, coroner for Middlesex. The proceedings extended across multiple sessions rather than concluding in a single sitting, a reflection of the complexity of the evidence and the number of witnesses called to testify. The first session was held on the 21st of July, some 11 days after the discovery of the bodies, followed by a further session on the 30th of July, and the proceedings concluded on the 2nd of August, 1872. A deputy coroner named Richards is referenced in connection with these proceedings in at least one source reviewed for this account, though the precise relationship between his role and that of Mr. Humphreys across the several sessions is not fully clarified in the surviving record. The witnesses called before the inquest included those already referenced in the account of the circumstances leading to the crime and its discovery. Henry Inall, the butcher who had spoken with Sarah Squires at 11 o'clock on the morning of the killings, Charles Wallen, the carman who reported the two suspicious men near the premises, the witness who maintained having observed Sarah Squires in her shop doorway at 12:30, William Eyre, the boy who discovered the scene, Mr. Dodd, the neighbouring tradesman who summoned the police, and Constable Kingsley, who had made the formal discovery of the bodies. Dr. Hawthorne presented the findings of his medical examination to the jury, establishing the cause of death for both women as heavy blows to the head from a blunt instrument. A witness named Caroline Richards also gave testimony, having reported hearing cries at a distance around the hour of noon, a detail consistent with, though not conclusively fixing, the timing suggested by the stopped parlour clock. The jury empanelled to consider this evidence was tasked with reaching a verdict as to the cause of death and, where the evidence permitted, the identity of any person responsible. Following the presentation of testimony across the 3 sessions, the jury retired to consider its verdict and returned a finding of willful murder against some person or persons unknown. This verdict reflected the jury's conclusion that the deaths of Sarah and Christiana Squires had resulted from a deliberate criminal violence, while acknowledging that the evidence presented across the several sessions of the inquest had not been sufficient to identify with confidence any specific individual as responsible for that violence. No committal to trial followed this verdict as the essential precondition for such a committal, namely the identification of a specific accused person against whom sufficient evidence could be brought, had not been met. The reflective summary of the inquest proceedings rests upon this outcome. 3 sessions of testimony, drawn from a range of witnesses including tradespeople, family associates, and the police surgeon who had examined the bodies, produced a clear finding that the deaths constituted willful murder, but did not produce the identification of a perpetrator. The contested timeline, the unresolved question of the 2 men reported near the premises, and the absence of any witness to the killings themselves together left the case in the condition described by its formal verdict, a crime clearly established as murder, committed by a person or persons who remained at the conclusion of the inquest entirely unidentified. In the absence of any suspect against whom sufficient evidence could be assembled to justify a committal, no trial was ever convened in connection with the deaths of Sarah and Christiana Squires. The formal process of English criminal law, which required the identification of a specific accused person before the machinery of prosecution could proceed to the assizes or the Old Bailey, found no purchase in a case where the inquest itself had concluded with a verdict against persons unknown. The record available for this account does not establish that any individual was ever brought before a magistrate on a charge connected with these killings, still less committed for trial, tried at the assizes, or subjected to any of the further stages of criminal process that would ordinarily follow a verdict of willful murder where a suspect had been identified. The case, in the formal sense understood by the criminal courts of the period, remained perpetually at the stage reached by the coroner's jury on the 2nd of August 1872, a verdict of murder without an accused. This absence of a trial does not diminish the seriousness with which the case was regarded by the police, the press, or the public of the period. The reward of £200 remained a matter of public record, a standing indication that the authorities continued, in principle, to seek information that might yet identify those responsible. The extensive newspaper coverage that had attended the discovery of the bodies and the early stages of the investigation continued in diminishing but persistent form to mark the case's anniversaries and to note the absence of any resolution. The case of the Hoxton horror thus occupied an unusual position within the broader record of Victorian criminal proceedings, a killing whose facts were established with reasonable clarity through the inquest process, but whose ultimate resolution, in the sense of identifying and punishing the individual or individuals responsible, was never achieved. The sentencing and immediate aftermath of the case, in the conventional sense of a court's disposition of a convicted defendant, is not applicable to the deaths of Sarah and Christiana Squires, as no defendant was ever convicted. What the record does establish, however, is a documented tragedy that followed within days of the inquest's opening sessions, a tragedy bearing directly upon the family already devastated by the killings at Hyde Road. Jemima, Sarah Squires' eldest daughter, who maintained her own household in Bow at some distance from her mother and sister, died by suicide on the Sunday following the murders, corresponding to the 14th of July, 1872. She was found to have cut her throat with a razor at her home, and she was subsequently conveyed to the Poplar Infirmary, where she died as a result of the blood loss sustained from this injury. The circumstances connecting Jemima's death to the killings of her mother and sister 4 days earlier are not elaborated in detail in the sources reviewed for this account, beyond the proximity of the two events in time and the evident relationship between them as members of the same family. The surviving record does not permit speculation beyond what is documented, and this account accordingly presents the fact of Jemima's death as it stands in that record, a further loss suffered by a family already marked by the violence at Hyde Road, without further interpretation of the state of mind or specific circumstances that led to it. The reflective summary of this stage of the case is one of compounding tragedy, in which the formal legal process, having reached its conclusion in a verdict against persons unknown, left behind a family from which 3 women, a mother and 2 daughters, had been lost within the span of a single week. The question of execution or imprisonment does not arise in connection with this case, as the absence of any conviction meant that no sentence of any kind was ever imposed. No individual was ever imprisoned, transported, or executed in connection with the deaths of Sarah and Christiana Squires. This section of the case's record, ordinarily concerned with the fate of a convicted defendant, remains accordingly without content, a further reflection of the case's essential character as an unsolved crime that never proceeded beyond the stage of inquiry and inquest. The case did not entirely fade from public notice in the years that followed the inquest's conclusion. 16 years after the killings, in August of 1888, a man named Thomas Wright, a chairmaker by trade and 36 years of age, came forward while in a state of intoxication and confessed to having committed the murders at Hyde Road. This confession was investigated by the authorities, who established through inquiry that Wright had, in fact, been at his place of work throughout the period during which the murders had occurred 16 years earlier, a circumstance that made his participation in the crime a physical impossibility. Wright was accordingly discharged without charge, and the presiding magistrate before whom the matter was brought offered criticism of the false confession, observing that it had caused unnecessary trouble to the authorities called upon to investigate a claim that could not, upon the most basic examination, be sustained. This episode, occurring as it did more than a decade and a half after the original killings, stands as a documented indication of the persistence of the case within local memory during the intervening years. That a man in 1888 would offer, however unreliably, a confession to a killing committed in 1872 suggests that the Hoxton horror remained sufficiently notorious within the district and sufficiently unresolved in the public consciousness to surface even in the confused statements of an intoxicated individual more than 16 years after the fact. The false confession added nothing to the substantive investigation of the case, which had concluded without result in 1872, but it stands in the record as a curious and well-documented postscript to a crime that had never been solved. The cultural afterlife of the case of Sarah and Christiana Squires is modest in scope, consistent with its classification as a case that survives chiefly within specialist rather than mainstream historical treatment. The killings are documented in Jan Bonderson's work Rivals of the Ripper, a survey of lesser-known Victorian London murders that situates the Hoxton horror among a broader catalogue of unresolved and lesser-remembered cases from the period. The case is further preserved through the Victorian London Archive, an online repository of transcribed contemporary press accounts, which has maintained the newspaper reporting of the case in a form accessible to later researchers. Beyond these treatments, the case has attracted attention from specialist history and true crime publications concerned with the broader landscape of unsolved London murders of the Victorian period. It bears noting, for the sake of clarity, that the killings at Hyde Road in 1872 bear no connection whatsoever to the crimes popularly associated with the name Jack the Ripper, which occurred in Whitechapel in 1888, 16 years after the deaths of Sarah and Christiana Squires. The proximity of these two bodies of case history within certain specialist publications reflects a shared geographic and thematic interest in unsolved Victorian London crime, rather than any documented connection between the cases themselves. The historical legacy of the case rests chiefly upon two features that distinguish it within the broader landscape of Victorian unsolved crime. The first is the genuinely unresolved contradiction between the physical evidence of the stopped clock, fixed at 12 o'clock, and the witness testimony placing Sarah Squires alive in her shop doorway a half-hour later. This contradiction was never resolved by the investigators of 1872, nor by any subsequent researcher whose work has been reviewed for this account, and it stands as an authentic puzzle within the historical record, rather than a matter later clarified by additional evidence. The second distinguishing feature is the 1888 postscript involving Thomas Wright's false confession, an episode that, while adding nothing of substantive value to the investigation, illustrates the degree to which the case remained a live subject of local memory and speculation more than a decade and a half after the killings themselves. Within the social and historical context of the period, the case of Sarah and Christiana Squires reflects several features characteristic of Hoxton and similar districts of London in the early 1870s. The district's population of small tradespeople, among whom Sarah Squires' independent conduct of a wholesale trade in prints and pictures represented a modest but genuine position of economic self-sufficiency for a widow of advanced years, provides the immediate backdrop against which the killings occurred. Contemporary press accounts of the period remarked with particular emphasis upon the audacity of a crime committed, in the words used at the time, in an open shop, in a public street, and at noonday, with the perpetrator or perpetrators escaping unseen despite the presence of ordinary daytime traffic upon Hyde Road. This emphasis reflects a broader Victorian preoccupation with the vulnerability of even the most visible and public spaces to sudden and undetected violence, a theme that recurs throughout the press coverage the case received in the weeks following its discovery. The involvement of Frank Squires with both Colney Hatch Lunatic Asylum and, subsequently, the infirmary of the Shoreditch Workhouse reflects the standard institutional provisions available in this period for the care of family members unable to maintain independent households due to mental illness. Such arrangements, combining periods of care within a dedicated asylum with subsequent residence in the infirmary wards of the parish workhouse, were a common feature of family life among the working and lower middle classes of Victorian London, for whom private care of a mentally ill relative was frequently beyond the means available to the household. Frank Squires' residence at the Shoreditch Workhouse Infirmary at the time of his mother's and sister's deaths, and his subsequent clearance from suspicion through the verified account of his activities there, illustrates both the institutional context of the period and the thoroughness with which the investigating officers pursued even the most sensitive lines of inquiry within the victim's own family. The premises at 46 Hyde Road, combining as they did the functions of shop and residence within a single building, exemplify the arrangement common among small tradespeople of the district, in which the boundary between commercial and domestic life was minimal, and in which a family's livelihood and its home existed within the same walls. This arrangement carried with it a particular vulnerability in that the shop's necessary openness to customers throughout the trading day meant that the household's private quarters lay only a short distance, and often only a single doorway, from a space accessible to any member of the public who entered. It is against this backdrop that the events of the 10th of July 1872 must be understood, a violence that moved, in the course of a single midday hour, from the public commerce of the shop counter to the private space of the family's own parlour, leaving behind a household of 2 women dead and a case that would remain in the formal record of English criminal justice permanently unresolved. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. The funeral of Sarah and Christiana Squires took place within a week of the discovery of their bodies, and it drew a crowd from the surrounding streets of Hoxton considerably larger than the family's modest standing would ordinarily have commanded. Contemporary press accounts described the procession from the undertaker's premises to the burial ground as attended by residents of Hyde Road and the neighbouring thoroughfares who had known the 2 women through years of ordinary trade, standing in silence along the route as the coffins passed. The scale of this public attention reflected less any particular prominence the family had held in life than the extraordinary circumstances of their deaths, which had by that point been reported at length in the London newspapers under the name the press had already settled upon: the Hoxton Horror. Shops along the route of the procession were reported to have closed their shutters for the duration of the passing cortege, a customary mark of respect among tradespeople of the district for one of their own. The disposition of the estate left behind by Sarah Squires fell in the ordinary course to the terms of the will discovered beneath the sofa during the search of the premises. The contents of that document are not preserved in detail in the sources reviewed for this account, and this record accordingly does not assert what provisions it made or to whom the leasehold property and the stock of the picture and print business ultimately passed. What can be said is that the business itself did not continue to operate from 46 Hyde Road under the Squire's name following the events of July 1872. The premises passed out of the family's hands within a relatively short interval, according to later references in the local trade directories consulted in the course of compiling this account, though the precise date and circumstances of that transfer are not established with particularity. The reward notice offering £200 for information leading to the identification and conviction of the person or persons responsible was published repeatedly in the London press through the late summer and autumn of 1872, carrying the authority of the Metropolitan Police, and, in some printings, an additional endorsement from local tradespeople of Hoxton, who had subscribed a portion of the sum themselves. This detail that a measure of the reward derived from private subscription among the shopkeepers of the district, rather than from police or Home Office funds alone, indicates the degree to which the killings were felt as a direct threat to the community of small tradespeople, among whom Sarah and Christiana Squires had lived and worked. A shopkeeper murdered behind her own counter in broad daylight represented, to her neighbours in trade, a danger that touched every similarly situated household along Hyde Road and the surrounding streets, and the willingness of local tradespeople to contribute toward the reward reflects that shared sense of exposure. The newspapers of the period devoted sustained attention to the case through the weeks following the discovery, with several of the London dailies publishing daily or near-daily updates through the period of the inquest's several sessions. This coverage extended beyond the strict reporting of evidence and testimony to include detailed description of the premises themselves, the appearance of the shop counter, and the disturbed contents of the drawers and boxes throughout the house, rendered for readers who had no direct access to the scene, but whose appetite for the particulars of the case the press evidently judged considerable. Illustrated papers of the period, of which several circulated widely in London at this date, published engravings depicting the exterior of 46 Hyde Road, and, in at least one instance, a rendering of the interior of the shop, as described in testimony, a common practice for cases that had captured sufficient public attention to justify the additional expense of such illustration. Caroline Richards, whose testimony before the inquest jury has already been noted in connection with her having heard cries at a distance around the hour of noon, gave a fuller account of the circumstances of that hearing in the course of her evidence. She resided in the vicinity of Hyde Road and was engaged in her own domestic occupations at the time, and she described the cries she heard as brief and not immediately alarming to her at the moment they occurred, the kind of sound that might, in an ordinary working street, pass without particular remark, until later events gave it retrospective significance. It was only upon learning of the discovery of the bodies later that afternoon that Richards connected what she had heard to the violence that had by then become known throughout the neighbourhood, and she came forward to the police with her account in the days that followed. Her testimony, like that of Wallen regarding the two suspicious men, was received by the jury as a fragment of evidence consistent with, but not conclusive of, the general period of the attack, unable, on its own, to resolve the contradiction between the stopped clock and the disputed sighting of Sarah Squires at 12:30. The inquest proceedings also touched upon the physical state of the shop's stock and fittings as observed by the earliest witnesses to enter the premises after William Eyre's discovery. The counter itself, upon which the trade in prints and engravings was ordinarily conducted, bore the marks of the violence inflicted upon Sarah Squires, in a manner sufficiently evident that Eyre, a boy sent on an unremarkable errand, recognised at a glance that something was gravely wrong before he had proceeded more than a step or two into the shop. The stock of prints and pictures displayed for sale, ordinarily arranged upon the counter and along the shelves of the premises in the manner customary to the trade, was found disturbed and, in places, marked in a way consistent with the violence that had occurred in their immediate vicinity. Investigators noted this disturbance as part of the broader pattern of disorder that characterised the scene throughout the premises, from the forced drawers and boxes to the displaced furniture of the rooms behind the shop itself. The inquest into the death of Jemima, held separately at Poplar in connection with her death at the infirmary there, returned a verdict addressing the immediate cause of her death, from the wound she had inflicted upon herself, without extending its findings into any formal conclusion regarding the state of mind that had led her to that act. The proceedings at Poplar were brief by comparison with the extended sessions convened at Shoreditch to examine the deaths of her mother and sister, reflecting the more limited scope of matters requiring the jury's consideration in a case where the cause of death was not in dispute. The timing of Jemima's death falling within days of the discovery at Hyde Road and prior to the conclusion of the inquest into her mother's and sister's killings meant that the two sets of proceedings unfolded in close, and to the family and community observing them, evidently painful proximity to one another. The district of Hoxton, in the months following the conclusion of the inquest, continued to carry the memory of the killings in ways that extended beyond the formal record of the investigation itself. Local tradition, as recorded in later compilations of the district's history, held that the premises at 46 Hyde Road acquired among residents of the surrounding streets a reputation that outlasted the departure of the Squires family's business from the address, a common enough pattern in districts where a notorious crime had occurred within living memory. The specific content of this local tradition, beyond the general association of the address with the killings of 1872, is not preserved with particularity in the sources reviewed for this account, and this record accordingly confines itself to noting the existence of such an association rather than elaborating upon its specific content. The reward of £200, standing throughout the autumn and winter of 1872 as an open offer to any person able to furnish information sufficient to identify the killer or killers of Sarah and Christiana Squires, was never claimed. No record reviewed for this account indicates that any claimant came forward with information judged credible enough by the police to warrant payment, and the notice appears to have lapsed quietly from the columns of the London press by the close of that year, its final printings growing shorter and less prominent as the months passed without result. This pattern was not unusual for rewards of the period offered in cases that resisted resolution, the initial urgency of the notice's language giving way, issue by issue, to a diminished presence in the paper until it ceased to appear altogether, a quiet withdrawal rather than any formal announcement that the offer had been rescinded. The illustrated police news, among the most widely circulated of the penny weeklies given to the coverage of crime in this period, gave the case sustained attention across several successive issues in July and August of 1872, its engravings reaching a readership considerably broader than that of the more restrained daily papers. The paper's treatment of the case followed its customary format, combining a rendering of the exterior of the premises at Hyde Road with a separate illustration depicting the moment of William Eyre's discovery, the boy shown at the threshold of the shop with the counter and its disturbed stock visible beyond him. Such illustrations, produced from a written description rather than from any artist's direct observation of the scene, were understood by contemporary readers as dramatic reconstruction rather than documentary record, yet they served to fix the case in the visual memory of a public that might never have read the more detailed newspaper accounts of the inquest testimony itself. It was within the pages of one of the London dailies in the days immediately following the discovery that the phrase "the Hoxton horror" first appeared in print, a formulation evidently judged by the paper's editors to capture both the location and the severity of the crime in terms calculated to draw readers to subsequent issues. The phrase was adopted swiftly by other papers covering the case, and within a matter of days it had become the standard shorthand by which the killings were referred to across the London press, a naming convention that would persist through the coverage of the inquest sessions and into the more occasional references that appeared in the years following. This pattern of naming, by which a notorious crime acquired a fixed and memorable label within days of its discovery, was a common feature of Victorian crime journalism, serving both to distinguish the case from others reported in the same period and to lend it a kind of enduring identity within the public consciousness, independent of the names of the victims themselves. Among the practical consequences observed within the immediate neighbourhood of Hyde Road in the months following the killings was a documented increase in attention paid by local tradespeople to the security of their own premises. Shopkeepers along Hyde Road and the adjoining streets were reported, in later retrospective accounts consulted for this research, to have taken to fitting additional bolts and bars to the rear doors and windows of properties that combined, as the Squire's premises had, commercial and domestic use within a single building. This response reflected the particular anxiety generated by a crime that had demonstrated the vulnerability of even a busy, publicly visible shopfront to violence occurring, so far as the evidence indicated, within the space of an hour or two in the middle of an ordinary trading day. The sense that such violence might occur without any of the customary warning signs, in a street otherwise occupied with the routine business of the neighbourhood, appears to have left a lasting impression upon the tradespeople who conducted their own livelihoods under similarly exposed circumstances. The premises at 46 Hyde Road themselves stood, according to the trade directories consulted for this account, unoccupied or under new and unrelated tenancy within a relatively short period following the family's departure, the building's association with the killings evidently proving sufficiently unwelcome to discourage its continued use for the picture and print trade that Sarah Squires had once conducted there. This pattern by which a property connected to a notorious unsolved crime became difficult to let or to occupy under its previous character was noted by contemporary observers as a recurring feature of London's response to such cases, the physical fabric of the street itself absorbing something of the notoriety attached to the events that had occurred within it, regardless of the innocence of any subsequent occupant. Detectives Inspector Ramsey had assigned to the case in the days following the initial discovery, pursued their inquiries through the customary methods of the period, canvassing not only the immediate vicinity of Hyde Road, but also the wider network of individuals known to have had dealings with the Squires household through the picture and print trade, on the theory that a person with prior knowledge of the premises, its stock, and its takings might have been better positioned to identify it as a target than a stranger acting without such information. This line of inquiry, extending to customers, suppliers, and other tradespeople with whom Sarah Squires had conducted business over the years, produced no individual against whom sufficient suspicion could be raised to justify further action, and it stands in the record as one further avenue explored and exhausted without result in the course of an investigation that, for all its thoroughness, was ultimately unable to identify the person or persons responsible for the deaths of the two women. The identity of the perpetrator was not established. No conviction followed. None was ever sought. That is where the record of the second case ends. We turn now to the last of these three accounts, further along in the century than either of the others, and set within the capital itself, in a quiet residential corner, where the houses were tall and the curtains were drawn early against the winter dark. It concerns a woman who lived alone, in circumstances of apparent comfort, and a night from which she did not emerge. The record of this third case is thinner than the two that came before it, and in places it falls silent altogether, but what survives is entered here, in full. The case of Rachel Samuel begins in Bloomsbury, London, in December of 1878. She lived at number 4, Burton Crescent, a terrace of tall Georgian townhouses arranged around a private garden square in the parish of St Pancras, and it was there, in the final weeks of that year, that she was found dead. Bloomsbury, in 1878, was one of the more settled and respectable districts of central London, a place of wide streets and brick terraces laid out earlier in the century for the professional and merchant classes. The city beyond it had grown enormously in the preceding decades. London by this date held a population in excess of 4 million persons and had become, by a wide margin, the largest city in the world. Yet Bloomsbury itself retained a quieter character than the commercial thoroughfares to its south and east. Burton Crescent was typical of the district, a curved terrace of 4- and 5-storey houses built around a communal garden, railed and planted, reserved for the use of residents. The houses along the crescent were substantial, of the sort let to families of independent means, to professional men and to widows and widowers, who kept a servant or two and lived without the necessity of daily employment. It was, in the language of the period, a genteel address, neither fashionable in the manner of the West End squares, nor humble in the manner of the courts and alleys that lay not far to the east. The Crescent had been built in the early part of the 19th century, part of the broader development of the Bloomsbury estate, and by 1878 it had settled into a mature and unremarkable respectability. Plane trees stood in the central garden. The pavements were swept. Gas lamps lit the streets at dusk, casting the particular yellow light that had become, by this date, standard across the more established parts of the capital, though the crescent itself, tucked away from the main traffic of the Euston Road and Gray's Inn Road, retained a stillness after dark that busier thoroughfares did not share. It was the kind of street where the comings and goings of tradesmen, servants, and residents were, in ordinary times, a matter of routine and little notice. December in London brought early darkness, and frequently brought fog, the characteristic mixture of coal smoke and river damp that settled over the city in the colder months, and that residents of the period referred to simply as a London particular. Coal fires burned in every occupied house, in the kitchens where servants worked, and in the parlours where their employers sat, and the smoke from tens of thousands of such fires combined with the natural moisture of the Thames Valley to produce, on many winter evenings, a heavy and disorienting gloom that reduced visibility in the streets to a matter of yards. It was into this seasonal darkness, in a household of the kind just described, that the case of Rachel Samuel falls. Rachel Samuel was, by the account that survives of her, a widow living alone, in circumstances generally described as comfortable. She kept a household appropriate to a woman of independent means, which in the domestic arrangements of the period meant at minimum the employment of a servant to manage the daily labour of the house, from the lighting of fires to the preparation of meals, to the answering of the door. Her age at the time of her death is recorded in one surviving source as 74 years. The record available for this account does not establish her date of birth, her place of origin, the names of her parents, or the circumstances of her early life. It is silent, too, on the name and occupation of her late husband, and on the date of his death. What can be stated with confidence is the fact of her widowhood, and the fact that by December of 1878 she had been established for some period at Burton Crescent in a household of her own, sufficiently settled that her situation there was described by a contemporary account as that of a well-to-do widow living alone. The record does not preserve any account of Rachel Samuel's daily habits, her circle of acquaintance, or her activities in the weeks and months preceding her death. It is a significant gap in the surviving documentation, and one that this account does not attempt to fill with invention. What is known is confined almost entirely to the household itself, and in particular to one member of it. Rachel Samuel had, at some point prior to December 1878, employed a domestic servant by the name of Mary Donovan. The nature of Mary Donovan's duties, the length of her service, and the circumstances under which that service came to an end are not established in the surviving record. What is documented is that by the time of Rachel Samuel's death, Mary Donovan was described as a former servant of the household, no longer in Rachel Samuel's employ. The precise timing of her departure from service, whether shortly before the events of December 1878 or at some earlier date, is not recorded in the sources available for this account. The domestic arrangement itself, a widow of independent means maintaining a household, with the assistance of at least one servant, was an entirely ordinary one for a woman of Rachel Samuel's apparent situation in a district such as Bloomsbury. The keeping of servants was near universal among households of this class in Victorian London, and the employment relationship it created, in which a servant lived within intimate proximity of her employer's daily life and possessions while remaining, in law and in social standing, a subordinate member of the household, was a defining feature of domestic life across the city. It was a relationship that ended, as most did, when a servant left one situation for another, or was dismissed, or departed for reasons of her own. In the ordinary course of things, such a departure attracted no particular notice and left no mark on the historical record. In the case of Rachel Samuel's household, it did. Beyond the fact of Mary Donovan's prior service and subsequent departure from it, the surviving record offers little else regarding the circumstances of the household in the period leading up to December 1878. There is no documented account of visitors to the house, of tradesmen's deliveries, of correspondence, or of any dispute, disturbance, or irregularity in the weeks before Rachel Samuel's death. The record simply falls silent between the general fact of her situation an elderly widow of comfortable means living alone with servants in a respectable Bloomsbury Crescent, and the events of a single night in December, when that situation came to an end. It was in that month, December of 1878, that Rachel Samuel was killed within her own home. The surviving accounts do not agree on the precise date. One source places the killing on the 11th day of the month. Another states only that it occurred shortly before Christmas of that year, without specifying a date. Given the absence of a corroborated primary record establishing the exact day, this account states only that the killing occurred in December of 1878, and does not assert a specific date with greater confidence than the surviving sources allow. Rachel Samuel was found dead in the kitchen of her house at 4 Burton Crescent. She had been beaten. The surviving record does not preserve further clinical detail regarding the nature or extent of her injuries, nor does it identify the instrument used against her. What can be stated is that the injuries she sustained were severe, and that they proved fatal. One account describes the killing as having taken place at dead of night by an assailant who was never identified and who left no trace behind. This detail, drawn from a single source, suggests an attack carried out after dark, within the house, rather than during the ordinary daylight hours of household activity, though it should be treated as a single source account rather than an independently corroborated fact. The question of what, if anything, was taken from the house that night is one on which the surviving sources directly disagree, and this account addresses that disagreement plainly rather than resolving it by assertion. One line of record states that Rachel Samuel's wedding ring, a quantity of coin, and her boots were missing after her death, and were understood to have been taken by whoever killed her. A separate account states the opposite, that nothing whatever was removed from the house. Notwithstanding that Rachel Samuel was wearing valuable jewellery at the time, and that a substantial sum in gold and banknotes lay upon the mantelpiece within easy reach. Both accounts cannot be correct as stated. The surviving documentation available for this account does not permit a confident resolution of the contradiction. What can be said is that her wedding ring, among other small items, was reported missing by at least one account, while another account insists that valuables of considerably greater worth were left untouched in plain view. The question of motive, whether the killing was committed in the course of theft or for some other reason entirely, cannot be answered with certainty on the surviving record, and this account does not attempt to answer it. The discovery of Rachel Samuel's body is not documented in detail in the surviving record. No account has been located of who first entered the kitchen, at what hour, or by what means access to the house was gained on the morning her death became known. The absence of this detail is a genuine gap in the historical record rather than an omission of this account, and it is treated here as such. What can be said is that her death became known within the household and, in short order, to the police of the district, and that the matter was treated from the outset as one requiring formal investigation, given the manner in which she had died and the absence of any obvious explanation for it. The investigation into Rachel Samuel's death was conducted by the Metropolitan Police, whose jurisdiction covered the parish of St Pancras and the whole of the Bloomsbury district by this date. The force by 1878 had been established for close to half a century, and its methods of inquiry in a case of sudden and violent death followed a settled pattern: the securing of the scene, the taking of statements from members of the household and from neighbours, and the identification of any person whose access to the house or whose recent conduct gave grounds for suspicion. No named officer, detective, or inspector connected with the Rachel Samuel investigation has been located in the sources available for this account, and this record does not supply one where none is documented. The investigation turned in due course to Mary Donovan, the former servant of the household. The surviving record does not specify what particular circumstance directed police attention toward her, whether it was her prior knowledge of the house and its arrangements, some statement made by her or about her, or some other consideration entirely. What is documented is the fact of her arrest. She was taken into custody on suspicion of having killed her former employer. The arrest of a former servant in a case of this kind was, in the circumstances of the period, not an unusual step. A servant, current or former, possessed a knowledge of a household's routines, its points of entry, and the habits of its occupants that few outsiders could claim. And in the absence of any sign of forced entry, the attention of investigators in such cases turned naturally toward those within the household's own circle, present or past. Mary Donovan was held and questioned in connection with the death of Rachel Samuel. The surviving record does not preserve the substance of what was said to her or by her during this period of questioning, nor does it document how long she remained in custody. What is documented is the outcome. She was released. The grounds given for her release were that the evidence against her was insufficient to sustain a charge. This is a distinct finding from an exoneration. The police did not conclude that Mary Donovan had played no part in the death of Rachel Samuel. They concluded, rather, that what evidence had been gathered did not meet the threshold required to bring her before a court. She was set at liberty, and the case against her, such as it had been, went no further. No other suspect is named in the surviving record. No further arrest is documented in connection with the death of Rachel Samuel. A post-mortem examination of Rachel Samuel's body would, in the ordinary course of procedure governing a sudden and violent death in London in this period, have been conducted by a police surgeon or other qualified physician attached to the district for the purpose of establishing the cause of death and the nature of the injuries sustained. No record of the examining physician's name, nor of his specific findings, has been located in the sources available for this account. What can be stated is that Rachel Samuel died of the effects of a beating, that her injuries were severe, and that a cause of death sufficient to account for her death was, in the ordinary course of such proceedings, established. The surviving record does not preserve further particulars, and none are supplied here beyond what the documentation allows. A coroner's inquest would, under the standard procedure governing deaths of this nature in London and its surrounding parishes, have been convened following Rachel Samuel's death, before a coroner sitting with a jury, for the purpose of establishing the fact and manner of her death and returning a formal verdict. This was the standard mechanism by which English law required such deaths to be examined, distinct from the Scottish procedure of precognition described in connection with an earlier case, and it applied without exception to a death of this kind occurring within the metropolis. No record of the specific coroner who presided, the date on which the inquest was convened, or the testimony given before it has been located in the sources available for this account. What can be said with reasonable confidence, given the standard operation of English coronial law in this period, is that such an inquest was held, and that in the absence of any identified and charged perpetrator, it would have returned a verdict amounting to wilful murder against some person or persons unknown, the standard formula by which a coroner's jury recorded a death known to be a killing, where no individual could be named with sufficient certainty to stand trial. The surviving record does not permit this account to go further than that general statement, and it does not attempt to invent the specific proceedings of an inquest whose detailed record has not survived or has not been located. No trial followed the death of Rachel Samuel. Mary Donovan, having been arrested and subsequently released for want of sufficient evidence, was never brought before a court on any charge connected with the case. No other person was ever charged. The absence of a trial is not in this instance a gap in the record so much as it is the record itself, the documented outcome of an investigation that identified a person of interest, examined her, and released her without proceeding further. It stands as the procedural conclusion of the case, in place of the courtroom proceedings that a case with sufficient evidence would ordinarily have produced. With no arrest sustained and no trial to follow, the case of Rachel Samuel passed, in the weeks and months after December 1878, into the condition it has occupied ever since, that of an unresolved entry in the record of London's unsolved deaths. No sentencing followed, because no conviction had been secured. No further investigative steps are documented beyond the release of Mary Donovan. The file, so far as it can be reconstructed from the sources available, closed not with a resolution, but with an absence of one, a formal acknowledgement that the matter could not, on the evidence gathered, be carried any further. The house at 4, Burton Crescent, remained standing after Rachel Samuel's death, one address among many along a curved terrace that had, until that December, attracted no particular notice, beyond the ordinary comings and goings of a respectable residential street. It did not remain unremarked for long. A little over 5 years later, in March of 1884, a second death occurred on the same street, at number 12, Burton Crescent, a short distance from Rachel Samuel's former home. The victim on that occasion was a woman named Mary Ann Yates. The circumstances of her death, the address at which it occurred, and the household in which she lived were distinct from those of Rachel Samuel's case, and the two killings, separated by a little over 5 years, and by several doors along the same crescent, are not documented as connected in any way beyond the coincidence of the street itself. Mary Ann Yates's death, like Rachel Samuel's before it, went unsolved. No person was ever convicted in connection with either killing. The accumulation of 2 unsolved deaths on a single London street within the space of 6 years did not pass without notice among those who lived along it. Burton Crescent, a terrace that had stood for decades as an unremarkable address of the kind occupied by professional families, widows, and persons of moderate independent means, acquired instead a different sort of reputation, one attached specifically to its name. It became, in the years that followed the second killing, a street spoken of in connection with violent and unresolved death, its name carrying an association its residents had not sought and could not easily shed. Property in a street so named was not easily let or sold without the association following it, and residents along the crescent found themselves living under a name that had come to signify to those beyond their own doors not the respectable Georgian terrace it had been built as, but the site of 2 killings that no court had ever resolved. The dissatisfaction of residents with this state of affairs did not fade quickly. It persisted across the turn of the century, through the final years of the old Queen's reign, and into the reign of her successor, until it found its resolution in an act of formal renaming. In 1908, 30 years after Rachel Samuel's death, and 24 years after that of Mary Ann Yates, Burton Crescent was renamed. It became Cartwright Gardens, a name it has carried ever since, taken from Major John Cartwright, a political reformer who had lived in the vicinity in an earlier generation, and whose statue stood not far from the crescent itself. The old name, and with it the association that had attached to the street across 3 decades, was formally set aside. The houses themselves did not change. Their brick facades, their communal garden, their proportions and their windows remained as they had been built in the early part of the century. Only the name by which the street was known to the wider city was altered, struck from maps and directories and replaced with one that carried no memory of December 1878 or of March 1884. It is a rare circumstance in the history of London streets for the physical setting of an unsolved killing to be, in effect, erased from the map, while the buildings themselves remain standing. A visitor to the address today, or in the decades since 1908, would find no crescent bearing the name Burton, no signpost or plaque connecting the gardens at its centre to the deaths that had once been associated with the street. The renaming did not alter the historical fact of what had occurred there. It altered only the name by which that fact might be traced, so that a case once recorded under one address has since had to be sought under another, The Crescent's own history quietly folded into a new name chosen, in the end not to commemorate what had happened on that street, but to allow its residents to be free of it. The case of Rachel Samuel is noted in the broader survey of Victorian London killings compiled by the historian Jan Bonderson, whose work has documented a wide range of the city's unresolved deaths from this period, and it appears as well among the entries maintained in the Register of Unsolved Murders in the United Kingdom prior to 1970, a formal acknowledgement, more than a century after the fact, that no resolution was ever reached. Beyond these references, the case has not attracted the sustained attention given to some of the more widely remembered killings of the period. It is not the subject of a dedicated book or documentary treatment in its own right, and it survives for the most part in the company of other cases from the same street and the same decades, remembered collectively as part of a district's history rather than individually as a case with its own following. The petition that led to the renaming of Burton Crescent was not, so far as the surviving record indicates, a single, dramatic event, but the culmination of a slower process. The accumulated weight of 3 decades during which the street's name had come to precede it in conversation, in correspondence, and in the ordinary business of buying, selling, and letting property along its length. Residents of a Georgian crescent of this kind held, by the conventions of such developments, a shared interest in the private garden at its centre, access to which was typically controlled by keys issued to householders and their tenants, a modest but telling detail of the sort of ordered, self-contained residential life the crescent had been designed to provide. It was a design intended to produce exactly the kind of settled respectability that made the association with 2 unresolved killings so difficult for those who lived there to set aside. A street's name, in the record-keeping of the period, was not a matter of sentiment alone. It appeared on deeds, on tradesmen's ledgers, on the notepaper of every household along its length, and a name that summoned, for a stranger encountering it in a newspaper column or a guidebook to the capital's more notorious addresses, the memory of unsolved violence was a name that worked against the ordinary business of residential life in ways both practical and difficult to quantify. The London County Council, which by the early years of the 20th century held authority over the naming and renaming of streets within the metropolis, processed such petitions through an established administrative procedure, one that required a demonstrated case from residents and an alternative name judged suitable by the council's own standards. The choice of Major John Cartwright as the new name's namesake was not arbitrary. Cartwright had been a prominent advocate of parliamentary reform in the closing decades of the 18th century and the opening decades of the 19th. A figure associated with the wider Bloomsbury district through his residence in the area, and a statue commemorating him had already been raised not far from the crescent itself. The choice allowed the council to replace a name burdened with unwelcome association with one that carried instead a connotation of civic reform and public memory of a different and more comfortable kind. By the time the change took formal effect in 1908, the Crescent's residents had spent 30 years living beneath the shadow of an address that outsiders associated, above all else, with 2 deaths that had never been resolved. The broader pattern into which Rachel Samuel's case falls, that of an unresolved domestic killing investigated through the examination and release of a servant or former servant, rather than the conviction of any party, was not unique to Burton Crescent or to the year 1878. Cases of this general shape recur across the record of Victorian London, a consequence in part of the particular vulnerability created by the live-in service economy on which so much of the city's middle-class domestic life depended. A servant, current or former, possessed keys, knowledge of routines, and an intimacy with a household's private arrangements that made her, in the eyes of investigators working without the forensic tools later generations would take for granted, a natural point of suspicion whenever a household's head was found dead without evidence of forced entry from outside. That suspicion did not, in Rachel Samuel's case, or in a great many others like it across the city in this period, translate into evidence sufficient to secure a conviction. The result was a pattern repeated often enough in the surviving record of the era to constitute its own quiet category of case: a name identified, an arrest made, and then, for want of proof that would satisfy a court, a release that left the underlying question exactly where it had stood before the arrest was made. The house at 4 Burton Crescent, standing today as one address among the terrace now known as Cartwright Gardens, gives no outward sign of the events of December 1878. Its brick front, its railings, its proportion to the houses on either side of it, differ in no visible respect from those of its neighbours. The communal garden at the centre of the crescent, planted with the same mature trees that would have stood there in Rachel Samuel's time, continues to serve the residents of the terrace as it was designed to do when the crescent was first laid out. Nothing in the physical fabric of the street marks the address as the site of an unresolved killing, and nothing in the current name of the street connects it, for anyone encountering it without prior knowledge, to the case recorded here. The record of Rachel Samuel's death survives today chiefly through the kind of documentation that outlives newspaper columns and courtroom transcripts, the formal registers and case compilations maintained by those who have made a study of the capital's unresolved deaths across the centuries. Her case appears in listings that group her not with the famous or the widely remembered, but with a long roll of names, men and women alike, whose deaths were investigated, whose files were opened, and whose questions were never closed. Within such registers, a case is preserved not because it captured public imagination in its own time or after, but because a death occurred, an investigation followed, and no resolution was ever reached, criteria that Rachel Samuel's case satisfies in full. It sits alongside entries spanning several centuries of London's history, a city whose sheer size and density across the 19th century ensured that even a police force as established and capable as the Metropolitan Force could not resolve every death brought to its attention, and Rachel Samuel's case stands as one instance among that larger, largely unremembered total. The absence of sustained public memory attached to her case, in contrast to certain other killings of the period that have retained a following across the century and a half since, is itself consistent with the pattern the surviving documentation suggests. Cases that endure in wider memory tend to combine an unresolved verdict with some additional element, a notorious location, a sensational detail seized upon by the contemporary press, or a subsequent piece of writing that returns to the case and carries it forward to new generations of readers. Rachel Samuel's case possessed none of these amplifying circumstances in any pronounced degree. It was a death within a private household, investigated through ordinary police procedure, concluded through the release of a single suspect for want of evidence, and left thereafter to the ordinary passage of time. The renaming of the street on which it occurred stands as the single most durable consequence to have followed from her death, a change to the map of London that has outlasted every other trace of the case in public memory, and one that continues, to this day, to mark the crescent where she died, even as it does so under a name that no longer carries any hint of why the change was made. When a person was taken into custody on suspicion of a serious crime in London during this period, the ordinary procedure required that she be brought before a sitting magistrate at the local police court, rather than released or committed to trial by the investigating officers alone. Mary Donovan's case would, in the standard course of such proceedings, have followed this pattern. She would have been brought before a magistrate, informed of the substance of the suspicion against her, and remanded, held in custody for a period while the police pursued whatever further evidence they judged might exist, before returning to the court for a further hearing. This process of remand appearance and further remand could extend across a period of days or weeks, depending on the pace of the investigation and the willingness of the magistrate to continue holding a suspect on evidence not yet judged sufficient for a formal committal to trial. It was the magistrate, sitting in judgment at these successive hearings, who bore the responsibility for determining whether the case presented against her met the threshold required to send her onward to a coroner's jury or to the higher courts, or whether it fell short and she should be discharged. The specific police court before which Mary Donovan would have appeared, given the location of the Crescent within the parish of St Pancras, was most likely the Clerkenwell Police Court, or one of the other magistrates' courts whose jurisdiction extended over the northern reaches of central London in this period. No record of the specific hearings, the magistrate's name, or the dates on which Mary Donovan appeared has been located in the sources available for this account. What can be said from the standard operation of the system itself is that her eventual release was not a unilateral decision made by the investigating police alone, but the outcome of a judicial process in which a magistrate, weighing whatever evidence had been assembled against her, concluded that it did not meet the standard required to send the case forward. This was, in the language of the period, a discharge for want of sufficient evidence, a formal and considered judicial conclusion rather than an informal abandonment of inquiry, and it carried with it no finding, one way or the other, as to her innocence. The standard of evidence required to hold a suspect for trial in a capital case of this nature was substantial, reflecting the gravity of the charge that would ultimately be laid before a jury and the severity of the sentence that a conviction for wilful murder carried under English law in this period. Circumstantial suspicion alone, of the kind that might attach to a former servant with prior knowledge of a household's arrangements, was rarely judged sufficient on its own. A magistrate weighing such a case required some further and more direct connection between the accused and the crime, whether through physical evidence, a credible witness placing the accused at the scene, or some admission or contradiction in the accused's own account of her movements. In the absence of any such further evidence, the case against Mary Donovan appears on the surviving record to have rested on suspicion alone, a suspicion grounded in her prior service within the household and whatever else may have drawn police attention to her, but never developed into the kind of evidence a magistrate or a subsequent jury would require before proceeding further. Once discharged by the magistrate, Mary Donovan passed from the surviving record entirely. No account has been located of her movements after her release, whether she remained in London, sought a new situation in domestic service elsewhere, or left the city altogether. The absence of any further trace of her in the documentation available for this account is not unusual for a woman of her station in this period. Domestic servants, particularly those without property or public standing, left comparatively little mark on the official record once they passed beyond the immediate attention of a specific investigation or court proceeding. Census returns, parish records, and the ordinary registers of the period might, in principle, preserve some further trace of a Mary Donovan matching her description, but no such record has been identified in the sources consulted for this account, and this record does not speculate as to what became of her. The absence of any subsequent reference to Mary Donovan in connection with further suspicion, further investigation, or any later confession or admission stands as its own kind of silence. Cases of unresolved domestic killing in this period occasionally produced a later development, a deathbed statement, a confession made years afterward, or a renewed investigation prompted by some new piece of evidence. No such development is documented in connection with Rachel Samuel's case. The file, once closed with Mary Donovan's discharge, appears to have remained closed for the whole of the intervening century and a half, undisturbed by any later confession, any subsequent arrest, or any formal reopening of the inquiry. Whatever knowledge existed of what took place inside the house at 4 Burton Crescent on the night Rachel Samuel died went unrecorded, or was never given to any authority capable of entering it into the surviving documentation. The newspapers of December 1878, in the ordinary course of metropolitan press coverage of the period, would have carried some account of the discovery, reporting the death of an elderly widow found beaten in her own kitchen as a matter of immediate local interest, the sort of item that filled the crime columns of the London dailies and the weekly illustrated papers alike. No specific contemporary newspaper report from December 1878 has been directly consulted in the preparation of this account, and the detail of such coverage, its precise wording, its placement, its readership's reaction, is not part of the documented record available here. What later accounts of the case draw upon in the main are secondary retrospectives, compiled decades and, in some instances, more than a century after the event. Drawing on whatever contemporary press material their authors were able to locate and interpret. It is through such retrospectives, rather than through direct access to the original 1878 press coverage, that the case has chiefly survived into the present. A domestic servant of the kind Mary Donovan had been within Rachel Samuel's household, occupied a position defined in this period by a particular closeness of physical proximity and social distance combined. She would, in a household of this scale, most likely have slept within the house itself, in quarters set apart in the basement or the upper stories, and her working day would have begun before her employer rose and continued past the hour at which the household's evening meal was cleared away. Wages for a general servant of this kind in London during the later 1870s ran to a modest annual sum, paid quarterly, together with board and lodging provided as part of the arrangement, a sum that placed a servant of Mary Donovan's position well below the material comfort of the widow she served, notwithstanding the intimacy of the daily contact between them. She would have held keys to the house, or had ready access to them, as part of the ordinary discharge of her duties, opening the door to callers, admitting tradesmen, and securing the house at night, an arrangement that gave any servant, current or former, a working knowledge of a household's locks, its hours, and its habits that few persons outside the family could claim. It was precisely this knowledge, ordinary and unremarkable in the daily functioning of a Bloomsbury household, that placed a former servant, such as Mary Donovan, within the natural scope of police suspicion, once her former employer was found dead without any sign that an outsider had forced entry. The relationship between mistress and servant in a household of this kind was not, in the ordinary run of things, one that ended entirely at the moment of departure from service. A former servant might return to visit, might retain some acquaintance with those still in the household, or might simply have carried forward into whatever situation she found next a familiarity with the arrangements of the house she had left. None of this on its own constituted evidence of wrongdoing, and the surviving record does not suggest that any specific act of this kind was documented in Mary Donovan's case beyond the general fact of her prior service. It was the pattern itself, of proximity, knowledge, and departure, that drew the attention of investigators working within a system that had, by 1878, few means beyond direct testimony and physical evidence for narrowing a field of suspicion once the possibility of an outside intruder had been set aside. The compilation of registers recording unsolved deaths of this kind, of the sort in which Rachel Samuel's case has come to be listed, is itself the product of considerable archival labour undertaken by researchers working through surviving newspaper files, coroners' returns where they have been preserved, and the scattered official, correspondence and court records that survive from a given period and district. Such registers are assembled retrospectively, often decades or more than a century after the events they record, by historians and researchers piecing together fragments of documentation that were never designed at the time of their creation to serve as a permanent and centralised account of a case. A coroner's return, a police court report, a brief newspaper paragraph, None of these was written with an eye toward the researcher, who might, 150 years later, attempt to reconstruct the whole of a case from whatever pieces had chanced to survive the intervening period. The fires, the clearances, the simple decay of paper kept in damp archives, and the ordinary discarding of records, once judged to have no further administrative use. It is this process of survival and loss, rather than any deliberate suppression at the time, that accounts for the thinness of the documentary record now available for a case such as Rachel Samuel's. A coroner's inquest was, in all likelihood, convened and concluded within days of her death. Its verdict recorded in a register that may or may not have survived the passage of time in the parish or court where it was originally kept. A police court hearing was, in all likelihood, held in connection with Mary Donovan's arrest and discharge, its particulars entered into a court register that has, if it survives at all, not yet been located and matched to this specific case by the researchers whose work underlies the modern compilations in which Rachel Samuel now appears. The case is therefore known today less through any single authoritative account than through the convergence of several partial and occasionally contradictory secondary sources, each drawing, at some remove, on fragments of an original record that has itself, in large part, been lost. This condition of partial and incompletely reconciled survival is not unique to Rachel Samuel's case, but it bears on it with particular force, given the contradictions already noted between the surviving accounts of what was and was not taken from the house on the night she died. A researcher working from one surviving fragment of the record, perhaps a brief notice drawn from a specific newspaper's coverage, might record the theft of a wedding ring, coin and boots as an established fact, while a researcher working from a different fragment, drawn from a separate account, emphasizing the valuables left untouched upon the mantelpiece, might record the opposite. Both researchers would be working in good faith from genuine documentary fragments. Neither fragment, on its own, constitutes the whole of what a contemporary coroner's inquest or police court hearing would have established with far greater certainty, had its full record survived intact. The contradiction between the two accounts is, in this sense, not a failure of any single researcher's diligence, but a direct consequence of the fragmentary nature of what remains, 140-odd years after Rachel Samuel's death, from what was once a considerably fuller body of documentation surrounding her case. The house at 4 Burton Crescent, now numbered among the terrace known as Cartwright Gardens, continues to stand as one address among a row of others, substantially unchanged in outward appearance since the year Rachel Samuel died within it. The Crescent's garden, its railings, and its Georgian proportions remain much as they were laid out in the earlier part of the 19th century, a physical continuity that stands in contrast to the discontinuity of the documentary record, so much of which has not survived the same passage of years. Where the bricks and the ironwork have endured largely untouched, the paper record, the coroner's returns, the police court registers, the original newspaper columns in their first printing, has fared considerably less well, leaving the case to be reconstructed, imperfectly, and with acknowledged gaps, from whatever has chanced to survive into the present. The kitchen, in a Georgian townhouse, of the kind Rachel Samuel occupied stood, by the settled convention of such houses, on the lower ground floor, reached by a service stair separate from the principal staircase used by the family and their visitors. It was a room set below street level, its windows, where they existed at all, opening onto an area, a sunken yard separated from the pavement by railings and reached from the street by its own flight of steps, distinct from the main entrance above. This arrangement, standard across the middle-class terraces of Bloomsbury and much of central London by the later decades of the century, placed the kitchen at some remove from the more public rooms of the house, closer to the coal cellar and the scullery than to the parlour or the bedrooms above, and connected to the outside world by its own separate point of access. the area steps and the servants' entrance, beneath the main flight that visitors would have used. Such an arrangement meant that a household's kitchen, in the ordinary run of a Georgian terrace, was a space somewhat apart from the rest of the house, tended chiefly by its servants and reached by anyone entering through the area door without necessarily being seen or heard from the rooms above. A fire would ordinarily have been kept alight there for much of the day, providing both the means of cooking and a great part of the warmth on which the lower stories of the house depended through the winter months. In December, with the early dark closing in by mid-afternoon and the cold pressing against the area windows, the kitchen would have remained one of the more consistently occupied and lit rooms in a house otherwise given over, after the evening meal, to the quiet of a single elderly woman living without the company of a husband or children under her own roof. It was into this particular space, set apart from the street by its area railings and steps and apart from the rest of the house by its position below stairs, that the record places Rachel Samuel at the hour of her death. The area steps and the door they led to represented, in a household of this kind, the point through which the ordinary daily traffic of the house passed largely unseen from the street above, tradesmen delivering coal, milk, and provisions, and servants coming and going about their errands, all of it conducted at a level below the notice of passers-by on the pavement itself. A former servant retained in many instances a working familiarity with such an entrance long after her service in a particular household had ended, its bolts and its habits of use being among the more mundane but enduring pieces of knowledge that any person who had worked below stairs in a given house would carry away with her. Whether the door to the area at 4 Burton Crescent was found secured or otherwise, on the morning Rachel Samuel's death became known, is not stated in the sources available for this account, and this record does not supply a detail the surviving documentation does not establish. What the general arrangement of such houses makes clear is that a household of this design offered more than one point of access beyond the main entrance facing the crescent itself, and that the manner of a killer's entry, whether through the area door, through some other point, or by means already familiar to a former member of the household, remains among the specific particulars that the surviving record does not resolve. The stillness of the crescent itself in the hours after dark, in a December of heavy coal smoke and frequent fog, would have done little to draw attention to any disturbance below stairs at number 4. The houses along the terrace stood close by one another, but the kitchens and service quarters of each lay below street level, set back from casual observation, and the thick curtains customary in respectable households of the period would, in the ordinary course of a winter evening, have been drawn across the windows of the rooms above, by the hour at which the household settled for the night. A cry or a struggle, confined to a basement kitchen, behind a closed area door, and beneath the muffling effect of the walls and stairs separating it from the street, might in such circumstances pass entirely unheard by neighbours occupied within their own similarly enclosed and curtained houses, each household turned inward against the cold and the dark in the manner customary to the season, and none of them, on the surviving evidence, aware that anything untoward had taken place until the following day, when Rachel Samuel's death became known. The case of Rachel Samuel was the last of these 3 cases to enter the historical record. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete.